Okay. So.
Είναι Teams, είναι.
Ναι. Είναι τα slides μου στην οθόνη. Τέλεια. Πάμε. Okay. Assuming that everyone can also hear me still online, I will also close the door. Welcome, everyone. I will say a few words to introduce the event, and then I will promptly give the floor to our lead editor, Professor Yannis Papadopoulos, to introduce the book. First and foremost, a big thank you to all the colleagues and students joining us on this occasion, either in person or online. Thank you to each and every one of you. It means a lot. I know it's a busy time for everyone. We have put together this small book launch event, bringing together both senior and junior discussants, whom we thank for their courage to participate in the event. And we are very grateful to a number of people and institutions. The sector plan rebalancing public and private interests for their kind support, as well as to Elgar Publishing for providing a few extra copies for the event. We're grateful to our good colleagues from Team Support and our student assistant, Bastian, who seated here, for their help with the organization of this event. A special thank you goes to Federica Violi, who has agreed to give me 100% research time and no teaching for the next 5 years. No? Well, it was worth trying.
It's recorded.
It's recorded, yes. So it's on record that I asked. So it became an obsession of mine to create a small collage of all the authors with their institutional pictures. It quickly became impossible. I couldn't access my own picture. Daniela and Sean have no picture online at all. Warren has a picture of a tree. So I couldn't save it either. So I put the picture from his LinkedIn that you can see in the middle, the picture of a rhino. So that's what you get. I cheated a bit also to include his real picture. He's actually down here, but it was not his institutional picture. But let me focus for a brief moment on the person on the upper left corner. When Yannis first approached me to co-edit this book, my first reaction was, thank you, but why? I didn't tell him, of course, I had to keep appearances, but as you may all know, Yannis is a household name in our field and also among EU lawyers, and I've been reading his work since my PhD years. What I didn't know at the time is that he's also one of the nicest academics around, and I had the chance to witness this firsthand, the appreciation and admiration that our colleagues have for Yannis and his work at the event in his honor last year in Lausanne. This is the nicest conference poster I have ever seen, showing Yannis during the different stages of his career. What Yannis forgot to tell me at the time was that the conference would be in French. Pas de problème, on purpose. Thankfully, my own panel was in English because of Matthew Flinders from Sheffield and other persons. Yannis, I promise you this conference is not in Dutch. We will be proceeding in English. It is primarily thanks to Yannis that we have this wonderful book out in the world. That's also here. And I give him the floor to introduce the edited volume. Thank you.
So good afternoon, dear colleagues, ladies and gentlemen. So it's a privilege and truly an immense pleasure to have the opportunity to present our Handbook of Accountability Research at the University of Rotterdam. Let me also warmly thank Professor Markakis for taking the initiative to organize this book launch event and for his extremely kind words today that I surely don't deserve. And of course, also the Erasmus School of Law and the Erasmus Center for Economic and Financial Governance for hosting our event. So as the lead editor of this handbook, allow me to take a few minutes to say a few words about this project. As you may have seen, the book starts with a jointly authored introduction. It's composed of 4 sections, respectively on politics, law, business, and work. There are 20 chapters, 5 per section. And let me tell you how much I enjoyed working with such wonderful co-editors such as Menelaos and Angela Hall. I don't know if Angela joined or she's online. Hi, Angela.
I'm here.
Hi. So Angela is following us online. And of course, with more than 30 chapter contributors too. The story started quite some time ago, back in 2020. So it was quite a long intellectual journey. And as you maybe know, in that kind of undertaking, there is no manuscript and no book out until the last authors have delivered their chapter. And they bribed me not to disclose their names. So 2020, you may remember that it was then amidst the COVID pandemic. And Edward Elgar asked me if I want to edit a handbook on accountability, maybe because they didn't have much to do during the pandemic. So my first reflection and answer were that, to be honest, it's similar to the answer by Menelaos. To be honest, I don't see the need for such a book, as we can still use the fantastic Oxford Handbook of Public Accountability that came out with Oxford University Press in 2014, edited by Mark Bovens, Bob Goodin, and Thomas Hillemans. The publisher tried to convince me that the future handbook would not come out before 2024, and that was overly optimistic, and that an update would therefore make sense. I remained unconvinced and continued to think and keep on thinking today that there's no reason to duplicate or even to update the Oxford Handbook. I started nonetheless realizing that what we miss is a volume with multiple disciplinary angles on accountability. And I made this alternative proposal to the publisher, and we agreed to move in that direction. So that's the origin of our project. And to me, it was obvious from the outset that such a handbook should include the legal perspective. And Menelaos immediately came to my mind as the obvious person to lead that section, as I had just read his great book on the Economic and Monetary Union. It was also clear to me that the handbook should do justice to the experimental work on accountability relations in the workplace, as I had come across Angela Hall's work through my colleagues who work in public administration, and especially the team at the Utrecht School of Governance that published a chapter in our volume. The fourth discipline that is represented in the handbook, it's management studies, business ethics and accounting, with works on corporate governance and social responsibility. I must confess I was initially hardly familiar with that body of work, so I learned a lot. Now, we can ask if these are the only disciplines that deal with accountability issues. The answer is no. However, although they are close to my discipline, so my discipline, let's say, broadly speaking, political science and public administration, well, sociology and history, they do not seem to place accountability at the center of their focus, to my knowledge at least. This doesn't mean, of course, that research in sociology or in history does not address issues of accountability. It's easy to understand why. Accountability relations, they penetrate all spheres of our everyday life. However, a proper reflection on accountability seems to be missing in sociology. I also came across work in contemporary history, especially work on transitional justice and reconciliation. This is a domain in which demands for holding past incumbents to account, these demands are a core element of the process. But I was not able, it's maybe my fault, to spot any major work with a historical long-term perspective putting accountability center stage. Finally, I would have loved to include philosophical contributions. As I know, there are vivid debates in philosophy around moral responsibility and related notions such as attributability, answerability, and of course, accountability. To be honest, I reached out to several scholars, but unfortunately, none of them was available to join the editorial team, which is a great one, notwithstanding these limitations. That's how we ended up, as the title of today's event suggests, 4 disciplines and 1 concept. A nice concept, some say a magic one, value-laden, also a fuzzy one. Our handbook is quite comprehensive, but it's not an all-encompassing encyclopedic volume. Having said that, well, I do believe that our collaboration across disciplines served, to me at least, as an eye-opener on topics and concerns that are common and transcend disciplinary boundaries. For example, political scientists and lawyers frequently study the same objects at national, European, and global level. Issues that are related to corporate governance, they are tackled by accounting specialists, legal scholars, and social psychologists too. And public administration and firm specialists both increasingly rely on similar frameworks to address inter-individual accountability relations. This is one thing. However, having said that, we should not underestimate, and I realized that after completing the volume, or while preparing the volume, we should not underestimate either the difficulty of speaking a common language on accountability across disciplines. For example, in political science, international relations, public administration, the principal agent framework is a major interpretive framework of accountability relations because it has to do with delegations. Corporate governance studies, for their part, they tend to view it as an ideological paradigm that guides the practice of accountability. Moreover, although we were not able to conduct a proper citation network analysis, it became visible, we realized during our editorial work, that the overlap in theoretical references remains quite limited across disciplines, testifying, I believe, to the persistence of disciplinary silos. Also, the core research questions tend to differ across disciplines. For example, political science scholarship essentially highlights the relational dimension of accountability, and therefore tends to leave the for what question, accountable for what, tends to leave this question open. Political scientists, we deal more with processes than with substance. Legal scholars, but I speak under your control, tend to focus on the formal frameworks that guide accountability relations. They address the how question much better than what we do as political scientists, seeking to locate the actors that are involved in an accountability relationship and to outline the potential consequences that may follow from such a relationship. As to the literature on corporate governance, well, this body of work tends to focus more on substance precisely. For what should firms provide accounts? And relatedly on the to whom question as well. To whom should firms provide accounts, justify themselves? And this is a question that is mainly addressed in normative terms, at least in the contributions in our volume. Well, to summarize, what I learned from this collaborative undertaking is that the conversation across disciplines is not easy. It encounters some obstacles, but also that there is a need for future, not just multidisciplinary research, as we did in the Handbook, but truly interdisciplinary work on accountability. Transcending disciplinary silos is likely to generate, I think, exciting novel insights through integration and cross-fertilization. Just to give a few examples. Political scientists, I have to praise my discipline, they do, I think, quite good work in uncovering how accountability develops or not, does not develop in practice. But we tend to neglect the formal constraints and opportunities on which legal scholars focus their attention. Legal scholars, in turn, but again, I'm speaking under their control, are maybe, I think, less interested in assessing the weight of informal accountability relations. And I think many disciplines would largely benefit from including the micro level perspective that is adopted by research on accountability in the workplace. Fieldwork, for example, is most welcome to study the accountability dynamics, as this has already been the case in research about public organizations, but also within the black box of private firms, corporations. So I'd like to conclude this short introduction with an invitation to consider this handbook, despite its 400 pages, just as a starting point. Thank you.
Yanni, you stay there as the chair also of the first panel, and I also invite the participants of the first panel, including the discussants, I would say, when you already want to, or you can join later too. That's also fine. So you did send me your slides, so I'll put them on the screen.
How many are we?
So let me stop sharing this one. I will open the slides. Okay. Yes.
To be in the frame for the.
Anything you want. You can be.
No,
I think
how much
they can see this basically, so they can. This. Floor is yours.
Thank you. Thank you so much for the introduction, Professor Papadopoulos. My name is Douwe de Lange. I'll sit down as well. I wrote chapter 10 of this book together with Professor de Jong. You'll notice Professor de Jong isn't here, so you'll have to do with me. Professor de Jong is a private law professor at Utrecht University. I studied at Utrecht University. I did the legal research masters there and wrote my thesis under Professor de Jong's supervision. During that period, I also co-wrote this article with him. And after that, I graduated and started working in practice. So now I'm a lawyer in Amsterdam. But just to clarify, I wrote this when I was a student still at university. I want to start today by referring to a play that I went to 2 weeks ago, which is called De Zaak Shell. Perhaps some of the Dutch people have heard of it. It's a play based on a climate case between Milieudefensie and Shell, which they at least claim is one of the biggest and most important claims, climate claims in the world. I tend to agree with them. It was a very good play. Unfortunately, it was the last performance, so you can't go and see it anymore. But I want to refer to it because they started the play by saying there's not so much a climate crisis as there is an accountability crisis. And I think that stresses the importance of us being here today and us writing about these topics and keep on writing about these topics, especially if we can from an interdisciplinary angle. Our topic is about tort law and accountability. So hopefully we try to do some interdisciplinarity there. And our question is how tort law can enhance or promote values of accountability. Then first, we have to understand how, if at all, do these topics relate. And this was literally our first meeting. Me and Elbert sat down and he drew this. and he said, we're going to write about what's in here, or try to find stuff that's in the middle of these topics. And accountability is of course a topic that's often referred to in tort law, but not so much as a normative value. As I understand, it's more referred to in public governance and public administration. But it's more of a system of norms and procedures. So we wanted to see how we could, if at all, relate these topics, and see from there if and how tort law can promote the values from the accountability discipline. Well, that brings us to the first hurdle, which is quite a big one. That's defining these two topics. As you mentioned already, Professor, accountability is, to say the least, a fuzzy concept, which I noticed immediately when I started diving into this literature. But of course, we're lawyers, so we want to have the premise ready before we start asking questions. What are these concepts? Before we start writing about how they relate. Well, when you Google scholar accountability, you very quickly find Professor Bovens, whose work on this I read extensively for this paper, for this chapter, I should say, who defines, and correct me if I'm wrong, two ways of looking at accountability very broadly, being accountability as a virtue, it's a normative concept, and accountability as a mechanism. And I should clarify, our goal in our chapter is not to give a new explanation of what accountability is. We just want to find some sort of definition, and if we can, a definition that has some consensus in literature, and use that for analysis of how accountability relates to tort law. Well, accountability as a virtue, there's a lot of discussion on this as well in governance and public administration, but we've distilled these four values, which come back in a lot of them, being responsibility, responsiveness, transparency, and democracy. There are definitely more that are mentioned. Effectiveness is one, and equity, I think, is another, but these four come back a lot. And if you have those four values, then there are ways in society to enforce them or promote them or enhance them. And those can be formal and informal. And as you predicted very well, we tend to focus on the formal ones as lawyers, which I'm going to do here too. Namely, what role can tort law, one of the formal systems, play in promoting accountability? All right, that brings me to the next concept, which seems maybe easier to define, but it's actually not that easy. And I'll give a very basic explanation on this. As I know, we are 4 disciplines, so not everyone has knowledge of what tort law means or what it does. I should clarify as well, this is about tort law in general. It's not about Dutch tort law or French tort law or European, it's tort law in general. That differs slightly per country, but at least in Western European countries, they're all relatively similar. The scope of tort law is bilateral conflicts between private parties where there is a claimant and a defendant. So let's say I buy a car from Josh, I think it was, and Josh hasn't mended the brakes, and he sells it to me and I crash it immediately. Then I can claim damages from Josh. And that brings the main question that always arises in tort law cases, is whether the defendant has sufficiently taken the interests of the claimant's interest into account. In other words, have they met the bar? Have they met the bar of the duty of care that we expect everyone in society to meet? There's a lot of examples. Well, I'm in practice now, so I see this all the time. If there's a constructor who builds a kitchen and he accidentally forgets the water input, then he's not met the bar of what we can expect of him. If you buy a car and the brakes are broken, you haven't met this bar. So far, so good. And there are usually very clear rules on this. But what makes tort law interesting is that there are quite a few open norms in tort law. And to my friends, I always try to explain it like this. Let's say you live in a student house, which some of you may still do. You may have a cleaning schedule. So every week I clean the kitchen, you clean the bathrooms, and blah, blah, blah. Those are rules. We put them down, and if you don't meet them, you get a fine. You have to cook, or I don't know. You have to. I used to have to pay. You have to pay a fine. Having those rules doesn't mean that during the rest of the week you can just leave all of your mess in the kitchen because we'll clean it on Saturday. So that's just to clarify that other than the rule that we've put down of cleaning every week, there's an unwritten duty of care that extends beyond this. In short, therefore, there are written norms that tort law takes into account and unwritten norms. That makes it an interesting type of law, and it also separates it from other types of law, for example, administrative law. These are, in short, the two axes that I refer to, both in a very basic explanation. Accountability brought back to the consensus that we were able to find in governance literature, and a very basic explanation of what tort law is and does. Then to narrow it down and to explain further how tort law can operationalize or enhance these values of accountability, we use the lens of climate litigation, because we found that it very well illustrates how it can operationalize and enhance these values of accountability. And then we focus on Dutch climate litigation because, for reasons I won't go into here, the Netherlands has been a very effective judicial system to bring these climate claims to. All right, that brings me to the actual contents of our chapter, the exploration that we did between these two concepts. On the one axis, we have tort law, as I explained, where we use the lens of climate litigation. On the other axis, we have accountability, where we have these four sub-concepts. And I'll just go through these sub-concepts quickly, and in all of them explain through climate litigation how tort law can enhance, promote these values. First, Milieudefensie Shell. I already referred to it in the beginning. One of the most famous and most written about climate cases in the Netherlands and in Europe and even the world. And it's really about this is about the duty of care. Shell, Milieudefensie says, has not met its duty of care in reducing its greenhouse emissions. That's an interesting and a difficult question, because there isn't a rule that says Shell has to reduce its emissions by X%. There isn't even a rule that says petrol companies or gas and petrol companies need to reduce their emissions by this and this percent. So to establish that Shell does have a duty of care, Milieudefensie has to construct this unwritten duty of care, like cleaning the kitchen, apart from the cleaning schedule. And this open norm in tort law provides a forum for that. But it's difficult. It has a high bar to establish that through the facts and circumstances and in the actions of Shell, we can establish that they have a duty of care and they didn't meet it. So what does Milieudefensie do? They throw into this bucket of unwritten duty of care the European Convention of Human Rights, UN norms, business standards, what has Shell done, yearly reports, everything. It's a 200, 300, 400 page document of establishing that Shell has a duty of care and they haven't met it. Perhaps you've read that in first instance they were successful. The court in The Hague said, indeed, Shell has a duty of care to reduce its climate or its greenhouse emissions by 45% in 2030 compared to, what was it, 2019. In appeal, however, which I believe was last year, the Court of Appeal held, yes, Shell has an unwritten duty of care to reduce its climate greenhouse emissions, but we're not going to put a number on it. Which makes it very difficult for Milieudefensie to then enforce anything because, okay, they have a responsibility, but to what extent? In any case, it's important to notice that this case, looked at purely, is just Milieudefensie against Shell. It's bilateral. It's two parties. However, following from that decision is a duty of care that counts for Shell, but other gas and oil companies, I guarantee you, are reading this judgment very closely and interpreting how does this duty of care count for me. Milieudefensie does this very, very smartly, also saying, okay, we know now that this duty of care counts for Shell, Exxon, BP. Be prepared because we're coming. That's all to say that tort law provides a forum when regulation fails or lags behind to establish duties of care that are not yet written down. They don't have a cleaning schedule yet for Shell, but we're going to try to find an unwritten duty of care for them anyway. Responsiveness, the second concept, is very closely related to responsibility. But it's about how tort law can try to move along with new circumstances, new societal circumstances, scientific circumstances, economical circumstances, whatever, to try and put down responsibilities. For example, in the end of the 20th century, railways were being built all through Europe, and regulation was basically not there. So they put all of these railways down and put trains over them and just said, okay, we'll figure it out as we go along. What happened was that all of these old locomotives caused sparks, which would sometimes cause fires in the fields of these farmers that the rails went through. And all of the crops would burn, even farms would burn, everything like this, and this would happen quite often. And throughout all the countries that railways were being built, cases were brought on, okay, maybe there isn't regulation on this yet, we don't have rules yet, but surely we have some sort of duty of care for these railway companies that they don't burn everyone's fields around the railway. And in most countries, these cases were successful, and they had to improve the safety of these of their trains and of the railways. Now, climate litigation shows a somewhat similar situation in that we don't have clear regulation for companies yet. The EU law, people will know more about this, about the CSRD and CSDDD that were there and then weren't there, and we're still developing them. But at least for now, as I understand it, we don't have clear regulation for companies like Shell on what they should do and when they should do it. So we're left basically with other systems like tort law to try and establish duties of care before we have actual written down rules on what they should do. One interesting climate case to mention here is Julia versus RWE. Julia, if I'm pronouncing this correctly, is a Peruvian farmer who lives in a village that's next to a glacier. And because of climate change, this glacier is melting. And to protect the village, Julia bought about $4 million worth, together with the village, of materials to protect themselves from flooding. Now, that's quite a lot of money, especially if you're a Peruvian farmer. So what he did is he started a case against RWE, which is one of the biggest energy companies in Germany and in Europe. And he claimed 0.47% of damages of the $4 million 4 million costs from RWE, saying you've contributed 0.47% to historic greenhouse gas emissions. Those greenhouse gas emissions cause the glacier to melt, which causes me to have to buy these materials to protect myself. So I want 0.47% damages from you. It's about $20,000. Now, $20,000 is pocket change for a company like RWE, but you can imagine that they were really scared of this case, because if he succeeded, you can imagine the entire world is going to come to Germany to claim damages from them for damages that were caused by climate change. Now, you can imagine that this is quite hard to prove. How are you going to say this glacier is melting exactly because of that emission? If I throw this bottle at you and you get hurt, sorry, Josh, get hurt, then it's very clear that I caused you damage. If I emit something here and it causes damage in Peru, that's much harder to prove. But luckily, there are developments here as well. They're developing, far smarter people than I am, are developing something called attribution science, which means that throughout models, they can now calculate calculate how certain emissions can lead to certain damages on one side of the planet to the other. Fortunately, Julia's case was dismissed last year, but there are other cases like this where they're trying to prove damages through this attribution science. I see that I have 1 minute left, so I'll go through the others quickly. Transparency. Tort law can promote transparency, which we've seen, for example, in US tobacco litigation. We know that a lot of tobacco companies have kept information about the damage of tobacco behind, and throughout cases brought against these companies, we found out that they knew and what they knew. There's a really good book on this by Ben Franta, which if you want to know more about this, I highly recommend. And lastly, which is a very interesting topic, so it's a shame I have to be quick about it, but
feel free to take another 2 minutes.
I'll do my best. Is democracy. A very interesting case here is Urgenda, which I assume most of you have heard the name of. It's a case where a foundation called Urgenda brought a claim against the state of the Netherlands, saying you did not meet the goals from the Paris Agreement, saying that you have to reduce by 25% in 2020 compared to 1990. By not doing that, you have breached your duties under the European Convention of Human Rights. And therefore, we want you to meet these goals. And they had an injunction. This case was successful, which was world news at the time, and also calls for a lot of other foundations in other countries to bring similar claims. And that shows how tort law can at least be one way of trying to fix government failures where politics fails. Regulation, for example, in climate change, but also in AI and in other fields of society, can lag behind. And if that happens and it's causing damages, causing risks for people, you can use tort law, as Urgenda has shown, to try and establish this duty of care before regulation does, and correct government failures when they occur. Now, you may also imagine that this has stirred up quite some discussion about the role of civil courts. You may have read that especially right-wing politicians were not particularly happy with the court saying to the government they had to do more about climate change. And this discussion is playing in a lot of countries, here and in the US as well. And that's a whole different topic that we could dive into for another hour. But it's interesting to see that tort law can, to a certain extent, be used to fill these gaps where governments lag behind or fail, within this playing field of discussion of what role tort law should play in society. Okay, wrapping up. I've tried to show how tort law can promote these values that we've found to be inherent or part of the broader concept of accountability. And our careful conclusion was that tort law can play an important but sometimes often overlooked role in promoting the values of accountability and filling these accountability gaps, especially if regulation and other means of accountability lag behind. Thank you very much.
Thank you.
Thank you very much.
We'll put on the next slides as
Of course. Shall I sit down there, or
you can sit anywhere on
on
my sides. I
The
will.
idea was to take the presentations in alphabetical order. Do you mind if
The next one being,
in Angela?
of course.
Okay for you, Sanneke?
I will.
Got up early.
Sorry,
Angela got up really early.
but you
To
too,
be
but
here
for
with
other
us.
reasons.
Yeah.
Angela, if you can hear us, shall I project your slides and control them from here, or do you want to share them? What do you prefer?
Be better if I can share them.
You can share, and then maybe that's easier, right?
Okay.
Can we
yeah.
see her if she shares her slides?
We're about to find out if we can see her, so let's see how that goes. Okay. That maybe actually works better because we can see at least a small part of you.
Yeah.
Okay. Floor is yours.
Cool. So are you seeing it okay? My first slide okay?
Yes.
Wonderful. So good morning, everyone from Michigan, and good afternoon for you all in Europe. I am always humbled when I interact with my European colleagues. Not only do I think you all are so fancy and you all speak multiple languages, well, I think I sometimes struggle with English. I've just been appreciative of how in this process, looking at different perspectives, not only from disciplinary, but even from country of origin. And that leads us to, a good entree to our topic, diverse perspectives, accounting for felt accountability of understudied and underrepresented employees. I'm Angela Hall, and I'm an Associate Dean in the College of Social Science at Michigan State University and an Associate Professor in the School of Human Resources and Labor Relations. I have with me my amazing former PhD student, Jacob McCartney, who is now a thriving assistant professor at Northern Kentucky University and their management department. So are you seeing my next slide? Did it advance to agenda okay? Okay,
Yeah.
wonderful. Okay, so what we're going to start off talking about is about what accountability is, and is it a universal construct? And then why do these questions even matter? Why should we care that accountability is experienced differently for people based on their background or their experiences? We're going to talk about individual differences in accountability and the research around that. And then we're going to talk about features of the accountability environment and wrap up with societal and organizational barriers and solutions. What I'm going to do now is that I'm going to turn it over to Jacob. And Jacob is going to talk about what accountability actually is.
Thank you. Is everyone able to hear me? Angela, are you able to? All right, beautiful.
I can't hear you, Jacob.
Well, that would be.
We can hear Jacob.
Yeah, we can hear you, Jacob.
Okay, beautiful. Within business, really what we care about with accountability is, are people responsible for doing their work? Are they going to be, do they know what they need to do, and do they feel a sense of duty to do that thing? So the classic definition is that accountability is an implicit or explicit expectation that one's decisions or actions will be subject to evaluation by some salient audience. And we'll get to salience a bit later. With the belief that there exists the potential for one to receive either rewards or sanctions based on the expected evaluation. And that's an area that I want to go into a bit more later as well in terms of that. A lot of the time we focus on the sanctioning focus with accountability, but it's also that you're rewarded for doing good things with accountability, and that is something that people generally enjoy more. So something that we want to encourage. Importantly, everyone is held accountable. So it is universal, but how it's enacted and interpreted depends on cultural differences. So to provide just a few examples towards that, in collectivist cultures, accountability is more frequently enacted within the team level versus in more individualistic cultures, it's more oriented towards the individual. And there's also this assumption within kind of weird countries, the Western, educated, industrialized, rich, and democratic, that there is this underlying assumption that everyone knows of accountability and kind of agrees to the standards that there are. But there are both shame and guilt-based countries in terms of that some individuals are more likely to try to avoid the responsibility if something goes wrong, because there's just kind of a shame towards if something went differently. So we can't just assume that accountability is interpreted the same by individuals across different cultures.
Great. So the question is, why does it matter? Why did we even write this chapter? Like Jacob had highlighted, is that a lot of the research, the majority of the research and accountability has been in weird countries. So Western educated, industrial, rich, democratic countries. And that research has typically centered around majority employees. So people who are white, people who are heteronormative, people who are, usually the people who are the folks who are considered to be the dominant culture. Our research, and I criticize myself in this too, really oftentimes centers around white collar workers, the people who have, the cushiest of jobs, who are working in offices, the higher paid workers. Oftentimes those are our samples. Educated people who are college educated, including science of the sophomore. So in the organizational sciences, we talk about this term for a while. Gordon et al. 1989 pointed out that a lot of our research is based on undergraduates at Midwestern U.S. Universities. So that is a really, really, really narrow type of way of, developing a body of research that we're going to try to extrapolate. And a lot of our fundamental research is based on experiments involving students. But the reality is that, where are those developing countries? Where are those second world countries or second power countries in these research studies? How about employees who are minoritized, underrepresented, understudied? And this could be in the context of race, ethnicity, gender. Even a lot of our studies have more people who identify as male than who identified as women in our organizational studies. Immigration is something that immigration status or citizen status is something that really hasn't been really viewed as a serious topic by researchers in the past. But we realize that people they migrate, and immigration status really has an important influence on how you interpret accountability. There's an article that just came out by Heiston et al., and he looked at workers from Eastern Europe who came to Western Europe to work and send money back to their families. And it was really, really important. Their immigration status really made them feel really connected to their work and felt like really so many people were relying on them, and submitting those remittance back home was very important. The other reality is that a lot of the research doesn't look at the blue collar workers, the precarious workers, the people who are engaging in poly work. So for example, people who are working multiple jobs just to survive, and gig workers who, as we have realized with the proliferation of people working on apps like Uber and such, a lot of people are working gig work, even though people have been working gig work since the beginning of time. So I'm going to talk about individual differences in accountability. Main individual difference has to do with personality. And there has been a small body of research on personality and accountability. For example, Frank and Ferris wrote about how conscientiousness can affect people's perceptions of accountability. Hall et al. Talked about extroversion and how extroversion may influence how someone views their accountability with respect to whether or not they're going to file a legal claim against their employee. But, you know, in the organizational literature, the big five personality traits, which are agreeableness, openness to experience, extroversion, conscientiousness, and neuroticism, have been a really driving force among a lot of the research. But there are kind of problems with that, because the personality testings have been normed across usually white, heteronormative, Midwestern samples. Now, over the last few years, there's been a change to overcome that. But the fact that, for example, we know that people of color in the United States are way more likely to score higher on neuroticism. That is something that needs to be addressed. And let me explain. Neuroticism doesn't mean it's a psychopathology. Neuroticism means that you experience more stressors. And when you take in consideration that, you know, the stressors that coexist with being a minoritized or underrepresented or historically marginalized person, it kind of makes a lot of sense. But these are things that accountability researchers have largely ignored. Let's talk about culture now. Gelfand, way back in 2004, I was in my PhD program in 2004. She talked about how accountability research was mostly in weird countries, and she was encouraging people to look at across different countries. That still is not the case. She highlighted that extra organizational source of accountability would be more salient in certain types of cultures. There are certain types of cultural norms that really impact how people react to accountability. For example, there's the black tax or brown tax remittance. There's a lot of research on that, and they call it black tax, you know, because a lot of that research came from Africa, or brown tax, like immigrants to the United States. But like I just mentioned about the Heist et al. Article, which talked about white Eastern Europeans submitting their remittance back to their home country. It's a notion that a lot of people feel that they have to help those in their family that who are less financially fortunate, and that becomes a stressor. It makes people, for example, potentially stay in jobs that they don't want to do. It makes them take in extra work extra hours, and that's something that accountability researchers in organizational studies really haven't looked at. Jacob touched on it before, how accountability is in collectivistic versus individualistic cultures. How, for example, team accountability might manifest itself in a collectivistic culture versus individualistic culture. Those are important things. Another thing that's important is the subculture versus the dominant culture. And I love the Grandy et al. Article and the McClooney et al. Article. One of the articles that McClooney writes is that she says it's called Calling in Black. And she talks about that some days it's just so exhausting to be a person of color that she doesn't want to call in sick to work. She wants to call in Black because she's just like, it's hard to handle the discrimination, the microaggressions, the other types of responsibilities that people may put upon people of color. For example, there's research that shows that people of color are often asked to assume certain types of work involving mentoring other people of color or doing extra DEI work or doing other types of things that are forward facing. I can give you an example at my university. There were very few people of color, but they wanted to be inclusive on a lot of the photos. So you keep on seeing the same people of color showing up all the time, right? And so they have to go to do photo sessions. And so those types of things have additional pressure. Also, we know that responsibility is an aspect of is a dimension of accountability, in that accountability to oneself is responsibility, and that has to do with one's values. And we know that people's culture can impact their values, whether it is based on, being a part of a subculture, being from another culture, or being even a part of a counterculture. And then the history of marginalization may impact how people respond to and react to accountability. People do not come to work just in a vacuum and divorce themselves of their experiences, but coming from a background of marginalization may make people interpret their accountabilities differently. So I'm going to turn it over now to Jacob, who's going to talk about features of the accountability environment.
Thank you. So with features of the accountability environment, accountability systems are kind of those more macro-focused structures that are in place, or formal systems that influence how people feel accountable, the experience of accountability. But in between that are the features of the accountability environment, which broadly speaking are these more phenomenological or experienced things that people feel, and different kind of ways to frame accountability. So with that, there are four main ones that are focused on within the literature: accountability salience, source, focus, and intensity. And with accountability salience, that's just how important is it that there is this accountability that's going on. So the example that I like is if you were in a supermarket, it's going to be more salient to you that you're not allowed to steal than if you're in a different setting. It's always the case that you're responsible for not stealing. But if you're in a supermarket and they have, I'm not sure if they have this in Europe, but they have this in America, cameras and videos that kind of show flashing that you're being recorded, that's going to make it more salient that you need to, not appear to be stealing from the supermarket. Accountability source, just that there are different people and different sources of accountability that you're going to have, that there are going to be, not just your boss holding you accountable, which is what we would typically think of, but you're also accountable to yourself. You're also accountable to coworkers. And, at least to some extent, you're accountable to the broader community. That being a difficult thing in terms of there aren't necessarily those formal accountabilities, but there are those consequences of how you are perceived in terms of whether people are willing to buy your products, whether people feel like you would be an employer that they want to go with. Accountability focus is looking kind of at outcome accountability versus process accountability, where if you're held accountable for an outcome, it's just, did you do something right or something wrong? Whereas if you're accountable for the process, you need to kind of follow the steps to lead towards the right outcome. And in practice, most of the time that's mixed. So if you're a surgeon, you're going to be responsible for following those right steps. There's going to be a check-in with your process, but we also look at, how many people successfully pass through the surgery and what their survival rates are. And then with accountability intensity, that's just the recognition that if you're being held accountable by multiple sources, you have a lot of different things that are weighing on you, that's going to lead towards stress, and that's going to lead towards differences in how you perceive the accountability. Angela?
Thank you, Jacob. So with respect to features of accountability, how we could apply that to studying underrepresented workers, when it comes to salience, more research that looks at cultures, values, and identity of historically understudied, underrepresented workers. Source, looking at different and added sources of accountability that underrepresented workers have, whether it's other types of labor, emotional labor that they have to engage in, whether it's different types of audiences that they have to react to. Those are important things to include. Focus. Oftentimes, people who are marginalized, they have lower ranking jobs, and those jobs oftentimes concentrate a lot on outcomes but not on processes. And so looking at how work can be shifted to give even lower status jobs more flexibility, because we know that when you give folks some autonomy, they feel more connected with their work, and it is a way of empowering employees. So lastly, talking about societal barriers and organizational barriers and solutions. So even in very progressive European countries, we still have an underclass. We have a bigger underclass here in the United States. Some types of barriers that people have are transportation, like not having reliable transportation. Solutions from an HR perspective would be transportation allowances and subsidies. Food insecurity. HR can do things like have food banks or referrals, or have subsidies for food. Mental health, even if you have universal health care, mental health is always a concern. And there are studies that show that even having additional support, such as corporate social workers, enhanced employee assistance plans, or wraparound services, which are services that will link employees to things like transportation allowances and food banks and such, really enhance the well-being of a worker personally, so that they can be a better and more present worker when they are at work. Another thing is a UN goal, sustainability goal 8, is having decent work. And part of that is having respect and giving people opportunities and have safety. And that could be a way of trying to live up to that UN goal and trying to increase the autonomy that even lower skilled or lower paid workers may have, so that their work can be more aligned with decent work. So for future research, these are some suggestions that we have. Talking about looking at how employees prioritize their accountabilities, particularly those of historically underrepresented workers who may have more accountabilities to to deal with in their life. Having more nuanced measures of accountability is the most used measure in accountability research and organizational studies. Has one of my closest friends, Wayne Hawkwater, and I always tease him and say, your measure kind of stinks. It really talks about white collar people, and it has a question like, if I don't do a good job, top management's going to hear about it. Most of us don't even ever see top management, much less a lower status employee. So have one that is more related to that. Looking at accountability over the life cycle of underrepresented workers, and also understanding the outcomes and reactions to accountability of underrepresented workers. Because although accountability is universal, felt accountability, we really can't assume that everyone's reactions to accountability will be the same. And with that, I conclude. Thank you very much.
Thank you so much, Angela and Jacob. I will quickly put on the slides. So Kuipers.
I'll try to be a bit briefer than I originally planned to leave some time for questions. First of all, dear audience, dear Yannis, dear Menelaos, dear Angela, thank you for having me here and for including me in your great book. I'm thrilled to be here and to be part of that project. I think that I have some coming out to do because of the disciplinary backgrounds that we all are in. I am a public administration scholar by training, so that's my natural take on accountability, but perhaps with a slight political science edge, which is very relevant because the chapter is about political accountability. And I'm going to discuss with you accountability in crises. Now, why? Does this just work with the arrows? Yeah. I look at crises. I think a focus on crises is important. You might say they are unique events, they are incidental, we cannot learn from them. But actually, crises are ultimate threats to core values of public sector organizations in democratic regimes: safety, security, legitimacy. The other characteristics of crises are, of course, urgency to intervene and profound uncertainty in doing so. But it's the threat that matters so much because public sector organizations play a key role in crisis prevention and response. After all, we need our governments and we expect from our governments to protect us from harm. We delegated the monopoly on violence to our government in return for protection. So it's a core thing that governments are about. So this is a real public sector thing here. And whenever a crisis occurs, or even a threat, this safety is jeopardized. So all accountability debates after or during a crisis focus immediately on the responsibility of public sector organizations and our governments. Let me see. I look at at crisis management from an organizational perspective, a public organizational perspective, and I discern in my chapter 3 types of crises. The first type is the crisis that hits the public sector organization immediately. The flood that floods its headquarters, the power outage that puts the whole system down. It completely upsets the organization's primary process or performance. And accountability questions usually pertain to what caused it and the immediate response. And then there's type 2, which is my favorite type, maybe. It's interesting because these are the crises that indirectly affect organizations. Say you're an inspectorate or a regulatory authority, and a crisis happens, safety is jeopardized, and your organization is held to account for not preventing it, for not regulating well, for not inspecting as you should have. So stakeholders attribute responsibility to this type of organization. The accountability question pertains to the performance gap that is being exposed because of a crisis. And then there's type 3, and those are crises about the organization. That's when things really go off the rails. For instance, when an organization's perceived performance over the long run is seen as is subject to intense criticism, as seen as structurally in decline. And the accountability question is about institutional legitimacy. Why do we finance these organizations with public means in the first place? Now, there's different examples of each type. For instance, the first type would be the NHS hospitals in the United Kingdom that suffered from a cyber attack at some point, which paralyzed all of its systems. And I think 9 hospitals went down for that moment. And that really paralyzed, of course, their primary process. The type 2 would be the Army Corps of Engineers in the United States when the levees failed during Hurricane Katrina. The Army Corps of Engineers had been responsible for upkeeping those levees. And after the flooding of New Orleans, everybody asked why this could happen. And lastly, the type 3 would be, for instance, the British Broadcasting Corporation, the BBC. After there was a reporter who accused the British government of sexing up their, sorry for my words, the evidence on the invasion of Iraq. So they from the BBC accused the government of disinformation, really, and then they had to expose their key informant. The informant committed suicide, and it became a major scandal because government punched back and said that the BBC was actually not doing their work well. And that unleashed a wave of criticism, not only on the BBC's reporter and specific case, but also on its editorial office, on its long run performance, on its financing, and on its legitimacy. So, how much time? My chapter discusses basically 3 different aspects of accountability. The crisis characteristics matter a lot for accountability. The conduct of the different stakeholders and the political executives accused, their organizational representatives, and the context in which this crisis takes place. They all affect the accountability debate, and they have different implications for each of these crisis types. To start with the characteristics, some type of crises have characteristics that have more impact because of the brutality of the harm done, because of the uniqueness of the threat or the crisis, because of the values involved. Sometimes, usually, crises that involve those that are most vulnerable in society, the sick, the young, the elderly. Those crises tend to arouse more public upheaval. So all that in terms of crisis characteristics matters a lot. And it's also often, of course, the result of framing. Whenever something occurs, a small symbolic incident or a major accident, opponents will rise to the occasion to accuse incumbents of the crisis situation and how this all could happen. And they will try to frame the issue as, of course, an accountability issue, whereas the incumbents will try to say that it's something in the sphere of the free market, or it's a private matter, or it's a matter of expert decision or confidentiality. They'll try to define it away. But framing by opponents will focus on the blameworthiness of the crisis. And that depends or is affected by the characteristics that you see here. And once the crisis has been framed as such, successfully also perceived as such in terms of severity and blameworthiness, blame avoidance becomes key for those who are in the hot seat. Is someone trying to attract my attention with that beep? Or okay. No, and then I'll just continue. Then there's, of course, the conduct of all actors involved, both the opponents and the incumbent politicians and the organization representatives. They have a lot at stake because being accountable means being responsible, which in turn means to bear the blame. And astute politicians, as research shows, will always try to follow the strategy, what we call stage retreat. They start with evading responsibility, and they only embrace more responsibility when the first strategy didn't work. So, although that almost always fails, they start with denial. No, now that doesn't work, but still, that would be maybe a first reflex. And then they will embrace responsibility, and only in the end, they will actually embrace culpability for the event. So that is one of the things that we always see also in crises. And what you can see is that this picture here, which visualizes this stage retreat, doesn't take place in splendid isolation, because different actors are starting to blame each other, and together they form a blame game. So it's not one actor going back and forth with the one media journalist or the one political opponent, but the one actor trying to evade the blame tries to, for instance, shift it to lower levels, who then start exposing that they were instructed to do so, whatever mishap occurred. And so blaming starts to interact actually between the different levels, and together they make things worse. And then finally, the context matters a lot. I'm also trained in institutional theory. So institutional factors, of course, affect all of it. We know from crisis communication theory that responsibility attribution is dependent on context. Timothy Coombs' situational crisis communication theory discerns between when an organization is seen as a victim of a crisis, when it's seen as maybe bearing some causality, but in an accidental way, the accidental cluster, as he calls it, or when intentionality is attributed to the organization in focus, and then it's seen as a culprit. But how this responsibility is attributed matters on depends on how much an organization has experienced or contributed to crisis in the past. So its own crisis record, or its own failure record, as you might say, basically makes attribution worse down the line. And also, when it has a stellar reputation in stakeholder treatment, it helps a lot. And when it's being accused of treating its stakeholders very badly before, then attribution of responsibility will be much harsher. We see also differences between political regimes, for instance. If you have a single party government, there's another accountability dynamic than in a coalition government system. For instance, one of my PhDs studied how the differences between the different systems in blame games. And there she outlined also how single party governments, they often have less of a tradition of ministerial responsibility. So ministers are not seen as responsible for previous government doings. But the debates are much harsher and much aggressive, and the incumbents are more defensive because it's personal. It's their own reputation is on the line. And in consociational systems where there's multi-party governance, a minister may have to step down because of misdeeds of a predecessor, but the debates are a little milder, usually. So what does that mean for the crisis types? Well, what we see is with the type 1 crises, those that directly hit organizations, the severity and blameworthiness are, of course, more immediately linked to the organization, which is underwater or in the dark. But the organization itself also has, in a way, more control over the narrative. Once they manage to get their message out, they have more likeliness to frame themselves as a victim of circumstances. And there are less others involved, implicated in the whole blame. And that is exactly what becomes very difficult in the type 2 crises, because these are usually, the blame is attributed because an organization is indirectly involved. It has some indirect responsibility for everything that has gone wrong, and so have others. And they start shifting blame to each other, because usually there's a network responsibility, and each of the network partners has more loyalty to the own organization and their own reputation to guard than that they have no loyalty to the larger network. So that is often when a blame game erupts. Then the institutional crisis about the organization is usually so profound and so much about the long-term performance and the basics of the organization that it calls for renewal. It calls for major reform. And there the organization is a bit on a crossroads, whether it can, whether its incumbent executives can take up that task themselves to introduce reforms, to start renewal, or that is imposed upon them. And that will depend also on whether they have good stakeholder relations, some maintaining credibility, internal support, and political clout as leaders to decide whether they are able to pull that off. So to wrap up, crises are therefore important markers in time, markers in the public sector landscape also. Accountability fora and political representatives have only so much time in doing their work in parliament or as oversight bodies, so they look at where things go wrong. And when a crisis occurs, of course, that's the instances that they focus on. So naturally, it is imperative for us to understand the accountability dynamics during crises, because they have so much consequences, because that's often when reforms are introduced or changes are being called for. So when safety and security are at stake, when political executives have to do the horrible twin task of managing the crisis on the one hand and being accountable at the same time, and when the stakes are high for both the incumbents and the political opponents. And that would be it.
Sure.
Thank you.
Let us continue the discussion now.
And we maybe invite
Yeah,
the
maybe
panel,
we invite the discussion.
maybe the whole panel this time. It also makes it easier for me to take pictures, so if you can. I'll stop sharing so we can also see our online participants. The president can.
Okay. Thanks to everybody. I'm going now to give the floor to our discussants. So we have the pleasure to have with us Mark Bovens. Mark is Emeritus Professor of Public Administration at the Utrecht School of Governance. But I would say above all, he's a leading scholar on accountability with major works and pioneering studies that have had and still have a lasting impact on thinking about accountability. We are also delighted to have a more junior discussant, Dion Rosa from the Erasmus School of Law, whose input will certainly refresh our discussions on accountability. So maybe, Mark, if you wish to start.
Okay, thank you very much, Yannis. Yes, I've been in the accountability business for quite a while. And like Yannis and Jill and Angela and Menelaos, I also edited a handbook on accountability in 2014, Yannis. And I have to admit that after that, I was fed up with accountability. I mean, this was such a lot of work. I think we had about 40 chapters. It was terrible. Such a lot of work. And I thought, well, everything what needs to be said about accountability has been said. But they proved me wrong. I had a copy of this handbook, and I really have to admit there are very many new insights. And there's no doubt that there's still a lot to be said about accountability, and a lot of research has been done and should be done. So I'd like to compliment the four of you and all the authors for a very, very concise and very effective handbook. Yannis gave a short introduction, and then he said, well, there should be another version because there's so much still to be said. And I agree with Yannis. So I have comments for each 3 chapters, but I'll end each of these comments with some suggestions for new sections or chapters, or even a whole new handbook. So
it's my turn to be fed up with accountability.
Maybe the young scholars will pick up the. So hopefully I can say some refreshing things. Let me start with the chapter on tort law by Douwe and Elbert. I think it's a great chapter. It's very coherent, and it convincingly shows that tort law can be a very helpful instrument for more specific tort law litigation. And for private law courts can be a very helpful instrument to enhance the accountability of corporations, but even of governments. And the chapter fills a gap, as much of the literature so far has been focused on public law and public mechanisms of accountability. And this shows that private law, where you have horizontal relationships, not vertical relationships, where, like in public law, where government can control or command the actors, but in private law, there's, as you say, a bilateral relationship. But even there, accountability can play quite a role, and particularly in your case, in the field of climate change and sustainability, it can help to provide more social responsibility. You end your chapter in the following way, and I cite, inevitably, the question does arise as to when and how the limits of tort law's contribution to promoting accountability are reached. I'd like to talk about the limits, not about the possibilities, but about the limits. And let me suggest you 2 possible limits as a follow-up, or as a new section or a new paragraph in your next in the next version, in the next edition. First, as far as I can see, tort law litigation is a very unequal playing field. Often it is. Many corporations have very deep pockets. They can afford very expensive law firms where you are working on. Yes. And they can afford long procedures. They have deep pockets. They have very deep stamina, have big stamina. Individual citizens often have no deep pockets and they have little stamina. So how to make the playing field more equal? How to get a level playing field? And my question would be, you didn't mention it, does class action, and we have new laws on class action, can they help to get a more equal playing field or not? Right? Does that help to improve accountability, to get a more even relation? Secondly, my second limit is that corporations can also use litigation, or only just the threat of litigation, as a way to intimidate citizens or NGOs or journalists who have critical questions about the conduct of organization. These are called SLAPs, strategic lawsuits against public participation. These are specific lawsuits which are not meant to get a case decided, but they are meant to exhaust and to intimidate the accountability, the accountee or the accountability forum. By the way of starting very costly lawsuits. I think of the way how Donald Trump, both as a real estate mogul and later as a president of the US, is constantly trying to intimidate opponents by using tort law. So, isn't there also a dark side to tort law litigation? And can it not also be used to diminish your points of transparency, democracy, responsiveness, and accountability? So maybe also we need a chapter on the dark side.
The dark side of tort law.
The dark side of tort law.
The title.
That brings me to the chapter by Angela Hall and McCartney. This is a very interesting and broad paper, and it testifies to the broad nature of this handbook because it's written from the perspective of behavioral sciences and not with law, and it focuses on individual accountability within organizations instead of accountability, more collective accountability of organizations. Hall and McCartney are very well aware of the dark sides of accountability. Accountability may cause stress, and this stress is not equally divided among employees. And that chapter is, as we've seen from the presentation, that chapter is very rich, very informative, and it touches upon a broad array of issues that underprivileged employees can be facing. What I found very insightful, also from my own work in their paper, are the often implicit cultural biases in accountability researches and practice. And these cultural biases come at different levels. First of all, they show that they come at the level of different accountability relations. Employees coming from more collectivistic cultures may experience different or often also more accountability expectations than employees from Western countries. Let me give an example, which I came across. At a conference, I had a talk with the Supreme Auditor from Angola. And she explained to me that in her country, the felt accountability of civil servants to the members of their extended families was much stronger than to the public service. Helping cousins with a license or helping cousins with a job was felt as a very strong moral obligation. This made her job far more difficult than the supreme auditors in European countries. I've worked for a while as a civil servant. I never felt any moral obligation to provide my cousins with a job. But in many more collectivist cultures, it's a real moral obligation. You're held accountable if you don't provide your cousins, you don't help your cousins who are in need. So that makes accountability much more difficult. And this may lead to different accountability expectations and intensities. And as they rightly say, immigrant workers may face more accountability demands, which may be difficult to reconcile. And what I find also very interesting, they point to the plight of street level workers who have many interactions with the public, but yet they're also accountable to their managers and to the public at large. And they may suffer more because of the high intensity and the conflicting nature of their accountability relations. In public administration, this is called MAD, multiple accountability disorder. They are from behavioral sciences, so I'm not sure whether it applies for DSM, but at least this is a difficult position. Finally, what I find most interesting is their suggestion. It was not in the presentation, but it's in the chapter. Is that the concept of accountability as such is rooted in Christianity. The notion of as I call it, an obligation of an actor to answer questions about his or her conduct, which may lead to judgment and consequences. That fits very well in a Christian culture of guilt and confession. But it may fit less well in a culture based on shame and honor, as they said in the presentation. In the Netherlands, recent research suggests that delinquents with a Muslim background get higher sentences than delinquents with other backgrounds for the same crimes. And one of the reasons may be that people with a Muslim background, who often come from the Middle East in the Netherlands, tend not to confess their crime, even in the face of overwhelming evidence, because that has to do with shame and with shame culture and honor culture. You never confess that you were wrong, at least not in public. But in Dutch culture, confessing guilt is a virtue, and it's a standard for accountability, and you get punished harder if you don't confess, if you don't plead guilty. Now, it may well be that this is a very useful standard, and that we should have it because it has all sorts of beneficial consequences. But nevertheless, Hall and McCartney's chapter have made me very much aware of the many implicit assumptions of accountability research and accountability practices. So I would suggest that in the next version of the handbook, we should have a whole section on cultural accountability studies. I suggest we have a section on cultural accountability studies, or at least on critical accountability studies. But of course, we already have this chapter. Finally, Sanneke's Kuipers chapter on crisis is exactly the sort of chapter that you would like to have in a handbook on accountability research and crisis. The field of crisis management is a very rich field with contributions from business management, politics, communication studies, etc. And responsibility, blame, reputations are at stake. And Sanneke gives a very rich and very competent overview of the many accountability issues that we just seen from her presentation. I only have two minor issues for the next version, for the next edition of this handbook. The first one is a conceptual issue. I was wondering, and I've struggled with this much myself, whether it makes sense to make a bit more distinguish more than you've done between accountability on the one hand and responsibility on the other hand. I struggled a lot coming from being a non-native speaker of English. In most European languages, only one word, that's responsibility, either in French or in Italian or in Spanish and in Germanic languages. But in English, you have accountability and you have responsibility. And they're not the same, but often they overlap or they're used. And so in your presentation, and my suggestion would be that, and most of your reflections deal with responsibility, which is the final stage of accountability processes, the stage of judgments and consequences. But at the early stage of accountability, we talk about accountability. Who is to be held to account? Who should we ask to step forward? Who should be singled out? And then we don't talk about responsibility or blame yet. We just talk about who's involved, who should be addressed to provide information. What are the relevant accountees and accountants? What are the relevant standards for judgment? So assigning responsibility is the outcome of accountability processes. So accountability is a process, and responsibility is more of an outcome, more of a judgment. And so accountability is a bit broader, I would say, than responsibility and blame. Secondly, having read the Hall and McCartney papers, there are two obvious questions come to mind. Almost all of your examples are from Western democratic countries, America, Europe, Britain. So, of course, the question rises, do we see different patterns of blaming and blame avoidance in non-Western, more collectivistic cultures? For example, your nice figure, about figure 3.1 in your chapter, and we saw it on the screen. Does your figure also apply in Japan or in China? Or do we see different strategies or different ways? But that
will be before.
that's what I'll be suggesting. And secondly, in your cases, the media and political opposition are pivotal processes of blaming and shaming. It's media, they do the framing, they do the blaming and the shaming, and it depends whether you have consensual or majority systems. However, an overwhelming majority of countries nowadays, an increasing number of countries, are autocratic, with very limited freedom of the press and very limited opposition. So to what extent are your findings applicable in more autocratic countries, such as in Russia, in China, or unfortunately increasingly also in the United States? So do your findings also apply in situations where you have autocracy or when you have electoral democracies or electoral autocracy, as Fabian called? So in your case, I also have two other suggestions for the next editions, for Yannis and Menelaos and for Angela and Jill. Maybe we should also have a section on autocratic accountability, or at least on comparative crisis management and accountability. So hopefully we're here in another 10 years and it will be.
Maybe on autocratic accountability, I published a very short book on accountability in the Element series of CUP. And I had a chapter on accountability in autocracies, but the publisher found the book too long. It's 25,000 words, too long. So I had to delete that chapter. But there is some material that is hidden somewhere.
I'm afraid there's quite a bit of need for a book on that topic, unfortunately.
Thanks very much, Mark. Before giving you the opportunity to react to Mark's comments, I would like to give you the floor for some further comments.
Thank you very much. Hard to follow on that, but I think I interpreted my role as giving my experience during that I had during reading your chapters, and also some questions or possible limitations that I thought of during reading it. First of all, for the tort law and accountability, I have to say, or as a small disclaimer, I worked on that topic for one of our assignments, so I had some background in the research. I think he showed very vividly how tort law can promote accountability, and especially what I thought was interesting, also the aspects on the informations, especially for the responsibility aspect. That was very interesting. And also the counter arguments that you brought to the criticisms that some people bring against the judges, or like the democratic legitimacy of using the judges for the decisions that at other points maybe the legislator should take. However, I also saw from my research, also from my German background, one of the possible limitations. I got that you wrote that chapter a couple of years ago, right? And I think since then, some NGOs also tried what happened with Multidisciplinary here in the Dutch system to do that in German jurisdiction, but they failed. And I think it is in the part of the responsiveness, not only of the tort law system itself, but also of the judges. So the judges in Germany are not that responsive compared to the Dutch ones for opening up the open norms in the national system for the interpretation of the standard of care as they are here in the Dutch system. And the main argument was, and that really suits your example with the norms that we have and the cleaning plan in a shared flat, for example, because they said that a company shouldn't be accountable if they were in compliance with the national laws. So there's no standard of care that goes beyond compliance with national laws. And that, in my eyes, puts a limitation to the tort law system that you have always, that you're dependent on the responsiveness not only of the system but of the judges themselves, and that could also lead further on to forum shopping. If you not only can shop the forum where the company has their main seat, for example, as we see in the Lucia case, that they went against RWE, but now they're not only shopping the forum where that company sits, they also shop the forum where they think the judges are the most responsive to that. And then I also wanted, or like one of my thoughts during reading it was that with the democracy aspect of it, is it really, should we go to private law courts for something that maybe the public law legislator didn't do enough? We see that with the, or if we agree that the main problem is that the overall economy doesn't do enough against the climate change, and the national legislation didn't do enough, they failed. That is one of the arguments, and now we have to maybe bring tort law into the position that we can use it so that the companies are more active. But we could also then sue the state to adapt its national legislation against that. So maybe from a democracy aspect, why do we use it's also the democratic legitimacy aspect that you found counter arguments against. Why do we use the private law judges to be active in that field when we could also sue the state to be more active with its legislation? That were my points that I had to your chapter, and then to the felt accountability of understudied and unrepresented employees. I have to be honest, like that is the chapter that I have, like in my early career or my studies, never had the contact with or with that field. So it was just, as you also said, very interesting to see these topics. And one of the most interesting aspects for me was, because I never thought about it before, that a main aspect of accountability for employees comes from within. So the subjective interpretations of accountability and of your role in the company, the self-evaluation, and you also spoke in the presentation about it, the accountability to oneself. That it's something that I took from the chapter. In general, I want to say that for someone who never really was in contact with that field, the chapter is very nice because it not only shows the current stand of the scholarship, but it also gives all the aspects where there are gaps and possible further points where scholars should go into. And maybe it's not only interesting for people in academia or students. I think it's that chapter is also highly relevant for every employer, because if you get the fact that accountability is not only a means of, cannot only be a means of punishing your employees, it can also be a reward. If you are able to frame accountability in your company like that, then the mental health goes up of your employees and the productivity goes up. So in my eyes, this chapter is highly relevant also, not only for academia, but also employers. And lastly, for the crisis management, very interesting, not only from my legal background, but also as one who's very politically interested. It's highly relevant in a situation where we see so many different crises right now at the same moment, and how actors react to it, and then seeing the study behind it, kind of, during reading it, and I'm interested to hear your thoughts on it. I always thought, how are these points applicable to the biggest crisis that we have right now with the climate crisis? And is it straightly applicable, or in my mind, it was kind of at some parts even the other way around, that we see legislators or people that are in power trying to be active and have crisis management, and then having other actors, the electorate or the society, who don't want them to be active in that crisis management. So kind of the accountability, or the people to whom they are accountable, they don't want them to be active in the crisis management. And also the framing of the crisis there is different in my eyes, because from the points that you said, normally the ones who are in power would say, nah, it's private, or it's not political. And then everyone else would say, no, it's your responsibility to be active. And here it's the other way around, that the ones who are in power, it's the other way around. So they are active, they say it's political. So the ones in power do crisis management, do something against the climate crisis, but then the private people or the opposition, the media, they would go against it and say, please refrain from being more active, putting more legislation out there. It's all private. We don't want you to do more in our private lives. So it's a bit, I thought about, maybe in the climate crisis, even though it's the biggest crisis we have, some of the points that you mentioned are the other way around. And maybe just as another aspect that I would like to hear, what do you think about how maybe all the aspects that you mentioned exaggerate in times of social media, when we see constant blaming, sometimes even the actions that people take as the people in power, that it's just blame avoidance, one could say. And we see even strategies from people in power, like I think it's a Trump administration saying it's flooding the zones. So you put so much blame into the world that it cannot come back to you. Yeah, these are my thoughts.
Thank you. So for the last round of this panel, I would like to give the opportunity to the paper givers to react to the comments. Maybe Douwe, shall we start with you?
Sure. Yeah. Thank you both very much for your comments. Really helpful. Perhaps to first go into the dark side of tort law. What we meant with saying that the boundaries of tort law are being tested is that more and more cases are being brought without precedent. So in climate litigation, for example, what we see these types of cases also being brought against large tech companies, for example. We're facilitating these kinds of cases, especially in the Netherlands, with the new law on mass claims. For those of you who don't know, mass claims are when a foundation represents a larger group of people in proceedings. In Urgenda, for example, the foundation represented all of Dutch society. The dark side of that can be that system gets flooded with all types of claims. And I think largely we all agree that climate claims are for the greater good. At least fighting against climate change is for the greater good. But you can also bring these types of claims for, I don't know, let's say you're very conservative and you don't think a certain group of people should be allowed to do this or that, or I don't know. You could use this system to try and also find change in ways that are not as positive. And as a lawyer, we try to not think about the outcome of these cases, but about the principle itself. How do these systems work, and do they have something to contribute? Tort law can also be used, like you said, in slap lawsuits. These are very much from the US. In the Netherlands, we don't see them as much, at least. I don't hear of them very often, at least. And not to insult Angela or Jacob, but in the tort law region, there are a lot of lessons to be learned from the US system in a lot of ways of how not to do it. Because it's almost part of normal conversation in the US corporate culture, at least it seems so in the movies, that everyone sues each other all the time and for far too much in the hopes of getting a little. This is, I think, what we want to prevent. You can have tort law and the private law system as an arena to discuss political change, the societal change, where that's useful and where judges can play a role. Like you said as well, judges have some sort of role to play in this, but it's tricky to find out to what extent that they can take this role. We see that in the Netherlands they are quite reciprocal to this, comparative to other systems. All of these new dynamics within tort law, especially in the last few years, are all the more reason to write about the counter sides of using it or using tort law in the accountability sphere. Just touching upon your last point, I think, about democracy, I tend to agree that just from an aesthetic point of view, it's much more effective and more direct to have cases against the government who can then regulate its actors, the actors in the country itself. So, for example, agenda. If you get the judge to say, indeed, the Dutch government, I don't care how you do it, but bring down your emissions by 25%, and they can then regulate how the companies should do this, like Shell, whatever. Apart from the fact that this judgment, even though it went to the Supreme Court, it didn't have the effect that the agenda wanted it to have. There's also the hurdle of that most of these companies are not just Dutch companies. Shell operates worldwide and arguably has a comparable amount of power as the Dutch state does, just in terms of how much money it earns and how much influence it has throughout the world. So for the Dutch regulator, if it gets one of these agenda claims through, to regulate all of Shell is not very easy. That's an argument to say, okay, we're going to try to take Shell into proceedings in the Netherlands, but maybe also in other states, try and also get a specific order for Shell. So to get them to do this and this and this and get a very specific claim against them to act more accountably. A lot of the lawyers and NGOs and funders that I talk to or read about all agree that suing Shell is not the most elegant or the most efficient way to get change. It's very expensive. It takes multiple years, and in the end, you're left with a judgment, which in this case seems out is not very favorable. It seems out it's not very favorable. For Milieudefensie and the lawyers who work on this, this is really it's years of, let's say, a life's work. And that's just Shell, and that's just Shell in the Netherlands. Then there's BP and Exxon and Total and all of these other companies who, if you really want them all to change, you'll need to sue them all. That's just to say that there are multiple routes how you can use tort law. None of them are perfect. We see a lot of these organizations trying to test the boundaries, and then after testing the boundaries, seeing what the effect is of getting a judgment. All of that causes discussion about the democratic role of tort law, how you can use it against companies and how you can use it against states. all of these dynamics are very interesting and to monitor and interesting to write about further, seeing how all of these developments will crystallize over the coming years. Yeah, I think I should leave it at that.
Thank you.
But thank you for both of your points.
Thank you. Angela and James, would you like to react to the comments?
Thank you. First, I want to say that the things that you've all have said about the United States, right on point. We're on fire right now. So no offense, but I would have a hard time living in Europe because I don't know if I'd give up my big gas guzzling car and my free refills on soda when I go to a restaurant. So I don't know. Those are important things to me. But no, I appreciate the comments that were made. Mark's comments, what really struck me was when you talked about the notion of accountability being Christian based versus it being, some other type of ethical or religious system based. And that is definitely true. I think of the work of one of our leading authors in the traditional accountability research here, Schlenker, and he has an article on Protestant work ethic, and that's been a dominant norm in the United States about how people work or how their attributions of how people should work, and that the notions of attribution really have salience within our own contents. And it makes me think of something else that I was doing at the same time as this book was we have a special issue of the International Journal of Human Resource Management on the topic of underrepresented workers in accountability, and it's going to come out in a couple of weeks. And one of the articles was written by Daryl Rice and colleagues, and he talked about how people who are African American will attribute accountability for bad behavior or abusive behavior against their bosses who they think are Trump supporters. So when that article came in, and as an editor, I felt really a little queasy about it because I'm like, oh, okay, this is a political time bomb. But my other associate editors convinced me, and we accepted it. And it really is important. And in retrospect, even though it was kind of risky, I'm glad we did accept it, because the notion of how people attribute accountability, especially within a certain type of paradigm, this Protestant worth ethic paradigm, is not the only way people attribute things. So thank you for bringing that up. Another thing, and forgive me, like I say, I even struggle with English, and it's really my only language. Do you pronounce your name Douwe, D-O-U-W-E? How do you pronounce it?
Douwe.
Douwe. Okay, and forgive me if I butchered it. Okay, it's a cool name. I like the fact that you brought up the notion of rewards, and Jacob has been from the time he was my PhD student, it's really talked about we really need to get away from the notion of always the stick aspect of accountability, but talk more about the carrot about accountability and how it can be used as reward. And the very nature of work, all of us, we work to gain money, but we also work to have respect and to have our self-esteem. We have value from work, and there's a reward in the actual of accomplishing things. And I think that that's something that our accountability research has really not gone in enough detail. And I saw that recently with work that I've seen in the literature about people who are low skill workers and who may even work at the hospital, but they still feel value in what they're doing because they're helping an employee. They're helping a patient, even if it's they're pushing someone around or cleaning a spill on the floor. Jacob, I don't know if you have any more that you want to say about that topic.
Yeah, just to marry the shame and guilt with the punishments and rewards, I think it's important to recognize that when you're going off of guilt, there's the reason why the guilt is effective is because if you confess and you have that recognition that you were accountable and you did something wrong, that eventually you can be forgiven and you can kind of go back into society in good standing. And I think it's where there are those aspects of shame, or there are those aspects of something that's unforgivable, where it's difficult to have that process bridged. And I think a lot of the time with the macro accountability within governments, within systems, there's this assumption that there can't be a process with which to move forward. And that's obviously very difficult because you can't just agree to ahead of time that you're going to forgive someone, because then they would have carte blanche to do whatever they wanted to do. But I think that it's that other side, that forgiveness, that's a lot more difficult, that isn't necessarily as well discussed within the literature, about how do you move past just holding someone accountable, how do you actually get to the point where there can be good behavior again.
Thank you. Maybe Sanneke?
I'm trying to think of one silver bullet to catch all compliments. So for the time remaining, and I think it should be a comparative study including Asian, African, and Latin American countries on climate change induced crisis and accountability. With a stronger conceptualization on the difference between accountability and responsibility. But the suggestions were great. So yeah, I embrace that, and there's lots to do.
So we already have many directions for a new volume. So you heard many of them. So now it won't be us any longer, but we hope that we'll find successors in.
I'm not doing this alone. I plan to retire, but we shall see. We will discuss.
It might be my posthumous work. Okay, thank you very much. Let me thank again the contributors and the discussants. Well, we are behind.
We will make up for it.
But I think well, first, can we maybe shorten a bit the break and start at a quarter to five, and then the next panel will be shorter because we have one paper less than initially scheduled.
Whoever wants coffee or tea or drink must follow me. Okay, thank you very much. Thanks for this.
Menelaos?
Yes, Andrea. Yes.
I just have a quick question. One second.
Yes,
just
let me pause the recording,
Yeah.
just in case.
Yeah, no, it's related, but
Actually, I will not stop it. Is it?
Sure.
If it's confidential, you can text me.
no, it's not confidential.
Okay.
I just want to get a sense of how in the room whether people have copies of the book sort of around them.
Most, not all.
Most, not all.
Yeah.
Because I just want to make a reference. I don't have slides, but I want to make reference to the two figures in my chapter, and it would just be easier instead of
That's totally fine.
I can
That's
share
totally
my
fine to do.
screen, but it's clunky, you know. All right, so
Yeah, I think it should be totally fine from my perspective.
yeah.
Yeah.
If you
And
maybe
it's
can
also
just
being recorded, so I think it's good also for whoever approaches this in the future to see, the direct reference. I think it's perfectly valuable.
all right, if you can maybe just if there is sort of when there's sort of an area where you can sort of see, there's not a copy of the book around, or so people can just look and share.
Absolutely. I will also give my copy around. Thank you so much, and we'll see you in approximately 17 minutes.
Yes.
Thank you. I am not muted anymore, so welcome back. So on that note, I suggest we move on to the second panel. I have to give apologies on behalf of Professor Diane from us, who due to serious personal and unforeseen circumstances, she may not be joining us. Let's see if she can join later online or not, but we still have two wonderful presentations and two wonderful discussants. And I suggest we follow still the order of presentations on the program. And there will be also more time for Q&A this time, and we're making up also for the time in the first panel. So do we start with Andrea or with Federica? Andrea, would you like to go first, given also the distance? And if you have any, you told me you don't have slides, if I'm not mistaken, right? So,
No.
Perfect.
Yeah,
So
that might come as a shock to my Erasmus colleagues because I usually know
Not
for
at
having
all.
lots of slides, but yes.
I will make sure
yes.
you're on everyone's screen as well. And yes, the floor is yours. Thank you very much.
Right. Okay. Thank you. Thank you so much, especially to Yannis and Menelaos for including me in this really interesting project. Accountability of international organizations have been part of my life. It's literally since when I was doing my LLM in public international law at Erasmus University, and also my PhD. And contrary to perhaps what is common, although I understand the sentiment, I am not done with accountability, because it feels to me the more I dive into it, the more I learn that there is more to know and to learn, indeed, as I've now also discovered from listening to you all and reading some of the chapters in the book. I want to start off and I'll explain a little bit in my background as I continue, because it's sort of relevant as to how I'm going to approach this. I want to go off script a little bit, and to start off at least with before looking at the content of my chapter, to talk about the nature of writing a chapter like this in an edited volume. I've been involved in a few of these over the past 10 years, I guess. It can take quite a long time to get published, except for this example. So kudos to Yannis and Menelaos. Relatively speaking, this volume was published, quite fast, and to all the other co-editors as well. And apologies for, from my side for causing, additional delays. I personally find writing for a volume like this extremely frustrating and challenging, and on the other hand also extremely rewarding, and it's really often both simultaneously. The reason I want to reflect about the nature of this is because it has implications of what is in the chapter and what not, but also because, and this is a suggestion perhaps that I want to add to Professor Bovens' remark about, a chapter to add for the future book, and that is one on methodology. We need to figure out if we all agree that we need to proceed from multidisciplinary work to more interdisciplinary work, which I absolutely agree with, that if this is the starting place, one of the impediments to do this kind of work, especially with the disciplines we have here today and the ones mentioned that are not yet part of it, is we don't know how to work together. It's not like a lot of the natural sciences where, various disciplines, they attack the same problem. I think, if you think about Artemis 2, and just all of those, the engineers and all the wonderful natural scientists, they're used to work in collaborative research and practical teams, and at least from my perspective, we are not. And a major impediment is methodology. We spoke about the issue of language, for example, and how to overcome that. So that's the other reason why I'm focusing on this sort of how to do this. As those of you who have done this kind of chapter in an edited volume, and the same, I would say, go for a themed journal issue as well, is, your biggest challenge is to figure out, especially if it's a topic that you actually do know a lot about, what on earth to include and what not, right? So the scope of what you include, especially because you always have word limits, but really what to hit the nail on. And for me, a good point of departure is always, okay, so whom I intend to address, who's going to be, at least in my mind's eye, who's going to read this. And so from my perspective, when I wrote this, I pictured, first of all, I'm an international lawyer. I'm an international institutional lawyer that focuses on international development law, which is actually the other aspect of international economic law that's often not really focused on. And for that, so it's international lawyers, but they're going to be academics first and foremost. And for that, they're going to have questions about theory and definitions. And for example, the distinction between accountability and international legal responsibility, which is something else that Professor Bovens mentioned. It's very much important to make that distinction because it's not used interchangeably in international law. It means very different things, and it has quite a lot of different implications. So that's sort of the first aspect of the chapter, which if you're not an international lawyer as such, you're not going to find it really interesting because, so what? But you can't, from my perspective, you can't exclude it because that would look like a glaring omission. But on the other hand, I can't say too much about it because it's not of, very, broad interest necessarily. But the other audience that I always keep in mind, and perhaps foremost write for, are students, LLM students, and also doctoral candidates. And I'm so happy that you guys are here today. And I'm so grateful to Menelaos and Yannis that they include you as well in the discussion, because, we talk about interdisciplinarity and the need for it, but we need different voices from new researchers, students and older people. We can get so entrenched in our old, mindsets, those of us who've been working in the field for quite some time. It is very important, I think, also to include different voices, also from different places. And for me, the other sort of aspect of my own pedigree that's relevant for this discussion is I'm a Dutch natural citizen. But I have been living in various places across the world because of my husband's work. Most recently, I've been living for the past 5 years in Charlotte, North Carolina. So hi to Angela and Jacob. But I am South African born and raised, and I have been privileged over the past 6 years or so to teach in South Africa regularly at University of Pretoria's School of Law, but with an LLM program on international trade and investment in Africa. So the nature of that program is that it is a selection of students from across Africa. So I've really been fortunate to get exposure to students from across Africa at the master level, and very experienced practitioners as well, and to answer, see what kind of questions they have. And that brings me to the other aspect of what I start off with is to why this and not this? Why this and why can't you do this and not that? Because to explain the structural deficiencies, I think they're deficiencies or shortcomings or limitations of the international legal order as it is now, or perhaps more accurately, what's left of it under the circumstances. We have to explain, to students, why not take it to courts, for example, in these specific situations? What are the limitations, indeed, of accountability and also of legal processes within, the specific context that I'm discussing? So a lot of that really is the choices that I had to make is to explain to, intended audiences, why this, what not, why not, and to make those kind of distinctions. And then to move on to the second part, which is really where I get into the gist of, accountability. Another decision that we have to make, to interrupt myself. The last portion of the audience that I typically write a chapter like this to are practitioners. It stems, I think, from the fact that I am myself a bit of a chameleon. I have had a dual career. I've trained in business and law, and I started off by working in business, not as a corporate lawyer, but truly as a specialist in project management, business process changes and change management. And so I come out of that world of work. And within the topic that I work with, international development banks, I'm regularly confronted with a variety of practitioners who are potentially interested in what academics have to say, but also the stuff that typically interests us when we really get giddy about, theory and philosophies and stuff. It's sort of, they're not that interested in that as well. So, and then within the context of which I'm working, when I say practitioners, I'm also talking about a wide variety of practitioners. I'm talking about international lawyers who are essentially institutional lawyers, like, the late Ibrahim Shahata, or investment lawyers who are very much transactionally focused. This investment contract or a developing financing contract. So it's very transactional focused, or project level transactions. But you're also typically working with lawyers who are on the other side, who are policy influencers, civil society advocacy groups, who are coming from very different perspectives and who have very different interests. And then within the institutions themselves, you guys have mentioned, cultural issues, take in institutions like the World Bank Group, and there you're working with economists, maybe a few social scientists, environmental specialists, but very much a different kind of. So it does create already a kind of a interdisciplinary world, if you will. And so when you're talking about the topic of international organizations, then specifically such as the development finance institutions like the World Bank Group and others, you're actually already in a very much interdisciplinary setting. So that was the other choice that I had to make, is when you talk about scope. Now, I had an option, and I do believe that Yannis and Menelaos actually would have preferred me writing something more sort of comparatively descriptive about different types of international organizations, because there are, as I mentioned, many of them with very different public international mandates, working within very different operational realities. If you're UNICEF versus one of the World Health Organization, the WTO, and then the World Bank, you're talking about very different realities. And that's the other reason why I decided to focus on this one subset of international organizations, which, thank you to Yannis and Menelaos, when I actually pushed back on that, they were gracious to allow me to do this. The reason why I focused on this specific international organization or type of international organization and their operational context there are a few reasons for it. From a methodological point of view, to just get back to the side quest that I mentioned, I think personally that one of the ways in which we can facilitate interdisciplinary and collaborative research is to get far more detailed from the conceptual level to the practical level. When words and definitions fail us, if we see something in what it looks like empirically or in practice, we can sort of make the connections to say, oh, okay, wait, so in my language or in my legal order or discipline, X means X, and here it means, but it's actually the same thing. Or we may be using exactly the same words, but it actually means completely different things, which also happens. So I think by really showing what something looks like in an operational reality and in different contexts actually helps and can facilitate, research, especially as we want to move forward to lower levels of, abstraction. And the other aspect of course, the multilateral development banks and the development financing operations are that they themselves have to operate in different national contexts in borrowing countries. So not the, Western donor and etc. Countries, or as we call them in international development law, the host nations. So capital importing or borrower countries. That is where the action, or a lot of it, takes place, especially when things actually go wrong, if not all of the decision making. So that is why I focus on that. And then the other dilemma that you have is, okay, so if you are focusing then on a specific example, what level of detail to pitch it? And not only with respect to word limit considerations, but if you go too broad or too vague at a high level, you can you lose people, and on the other hand, too much detail, you can have the same thing. So it's really a challenging thing, and for me, this makes it one of the most, I think, difficult things that I've written, but also the most rewarding ones as well. So that was the reasoning behind that kind of decision as well, to say, well, I'm going to focus on this one specifically. Instead of slides, if I may direct you to the book itself, so page, I think it's 161 to 162, if you have the copy handy. So I have two figures in there. Methodologically, I have found that I tend to think in pictures, but so that suits me personally. But it also helps me to teach. But I also think, and I've experienced this, that it can facilitate collaborative research also across the disciplines. So just to have a look quickly at those two slides. So this is the world of the development financing, world. Let me just open this one. So on the one hand, we have the project cycle, as we say there, project identification, design, appraisal, financing, implementation, and closure. And then, as you can see, there are also a lot of due diligence happening before and after. But on the other hand, and this is sort of the other slide that I want to focus on, is really with respect to accountability. So my point is that we had to make do in international law and international institutional law with starting to rely on the notion of accountability at a far, at very early on in what we were doing, because of the shortcomings within the international legal system, and also because practice simply dictated. So if you look at that slide, and it's based on well, it started to be based on work done by the International Law Association in the 2000s, where they try to adopt something that can be both legal and different forms of legal or quasi-legal, but also can potentially be interdisciplinary in terms of adopting other forms of accountability. Interestingly, it started when I certainly started to look at and really focusing on work, I guess, from political scientists, which is what Yannis mentioned. For me, the journey also really started with to whom, accountability to whom. And the for what aspect came actually much later in my research, when I realized, hang on, for what is actually a fundamental important concept here, because in this context at least, and perhaps in others as well, there is quite a bit of disconnect between different stakeholder groups and sometimes also within stakeholder groups as to the for what question. So if you, in the context of development finance operations, as reflected in that project cycle, there are really two different paradigms at work. And I argue that, stakeholders are not even explicitly aware of it, or certainly not most of the time, and that as to how these different contestations influences their ideas as to, pretty much everything, as to whose interests should have primacy when you talk about to whom. What should you emphasize when you're talking about yardsticks, right? Is it more important to have performance indicators or, normative standards, for example? And then ultimately, it is also really very much a contestation between which of these mechanisms of enforcing it, making sure it is applied, these indicators and standards, whether it should be focused on it within the institution itself, institutional mechanisms, or so-called citizen-driven mechanisms, like these accountability mechanisms that I described, like the Inspection World Bank Inspection Panel and the Compliance Advisory Ombudsman of the International Finance Corporation and MIGA, Multilateral Investment Agency. So, and then also to where it is indeed possible with respect to standing, national courts. Could you, for example, take in the borrowing country or the host nation, the national authorities to court there, sometimes also under the auspices of tort and or constitutional kind of questions. But I think the accountability for what aspect, the do good, in other words, execute the mandate, the public development mandate, to realize these very important development objectives, including environmental, social, and governance objectives, versus the do no harm, remedy harm, manage risk, especially around environmental and social risk for very vulnerable people, for vulnerable environments, through a risk mitigation strategy. Whether those two things, how well an institution is doing it and how it accounts for those actions, is very much reflected in contradicting, very strictly conflicting ideas about what outcomes should be ensured and which also is more important. And also, how effective are these then standards in particular and these mechanisms to ensure these outcomes. From a performance perspective, as in do good, realize the public development mandate, it is about making sure that those objectives are delivered, that there's a positive impact. They talk about, delivering ESG results, and not only from an economic perspective, but like a positive perspective. And then on the other hand is manage these risks, identify, mitigate, and very importantly, when things go wrong, remedy that harm. And whether whether these accountability mechanisms are effective is very much a question as to which one of these two paradigms really has precedence or preference within the group. Is it the remedying or do no harm, or is it the do good, the performance kind of perspective? And then, for example, another thing that an outcome that is very much, I think, still an issue, even though the emphasis nowadays is more on remedying harm, is I say they strengthen capacity to deliver positive impacts. That has to do with institutional learning through accountability mechanisms, which is something that we see, which is really, really problematic within these organizations. They tend to make the same mistakes over and over and over and over again. And they really try to avoid acknowledging that indeed they were, they did not comply, and therefore it resulted in harm. And then lastly, which is an aspect that I've started to add recently, which is also the aspect that I think where most of the research still needs to happen, and certainly going forward, and where indeed interdisciplinary approaches are crucial. Whose accountability are we talking about here? And as I mentioned there in some of the examples as to how many actors are involved in different and often overlapping capacities, different mechanisms, different configurations of contracts and memoranda of understanding and parallel mechanisms and co-financiers and just different actors. Whose accountability are we talking about? And how, if there are all of these actors involved, how can you actually share or proportion that accountability amongst those kinds of actors? And that is still a huge, huge area that needs to be, developed. To conclude, I think one of the aspects, certainly for international lawyers at the moment, is, if I look at the books behind me, and I do feel a bit of despair, thinking what is left and what is not. I've had a discussion recently with my PhD supervisor, recently retired Professor Elena, and we're talking about. She said she got the manuscript of her last publication just as she retired, and fortunately, she said it was without her thinking about it, was an historic perspective. So she's an international environmental lawyer. So it was a lot of, reflecting and about history and so on. So at least, it's not like, things can be contradicted at the moment, given this, the state of uncertainty and flux our discipline is in at the moment. And so I think, Yannis mentioned, historians and their involvement. Something that I try to do is also to look back and to reflect. So to, in this instance, to get off this accountability mold, because there's always something more to be done, to the point sometimes of exhaustion and frustration. But on the other hand, the work is never done. But if we look back, certainly where we are now, we are reminded how far we have come already, but also what we have to lose, and what we really actively have to fight for, I believe. So I think that kind of historical aspects are also very important. But also really to reflect on the need for building resilience in not only in law and in legal systems, but in the institutions that we've created to ensure accountability. And I think that is especially where we have much to learn from each other. Finally, I was really struck by just listening to the presentations, and I haven't read every single chapter in the book yet. I'm waiting to have the hard copy in my hands. Me and Google Play are not always friends. But, I looked at just the contributions of today. And obviously, Diane with the EU law and Federica, Federica and I have talked a lot about, the shared contexts that the example that I mentioned here had. But what really struck me, and I've made extensive notes, is really listening to Douwe's presentation, for example, on really tort and on the standards of care. So I mentioned in the chapter as well, a huge issue as to defining the actual scope of accountability of multilateral development banks, or how they interpret their due diligence responsibilities. And due diligence then also as a recognized principle of international law, what that actually means in this context. They tend, unsurprisingly, to want to have it as narrow as possible, with more responsibility shifted to the borrower, which is responsible to deliver this project according to their standards. And on the other hand, accountability mechanisms like the inspection panel, like the compliance advisory ombudsman, they tend to want to interpret it in such a way to broaden the accountability of the institutions themselves, which also, coming back to one of the things that Professor Bovens said, talks about the limits of accountability as well. Where is that margin of appreciation drawn? And that is absolutely a due diligence standard, and often involving long chains of accountability, especially where there are intermediary financiers as well involved. With respect to Angela and Jacob's presentation, I very much agree with your suggestion that it is really important to marry research on this felt accountability with accountability systems. And something that I've picked up and haven't referred to in the chapter as well, but in previous research, is also the role of institutional culture. Others have written, for example, about culture in the World Bank with respect to their approaches to human rights. And you have this clash essentially between economists and anthropologists or other social scientists and environmentalists, and that really makes for an interesting thing as well. And of course, in every country, if you are financing and implementing a project in China versus India versus Nigeria versus Mozambique versus Venezuela, it really creates quite a different culture. And then the questions with respect to accountability comes as to say, well, how flexible can you be in those in terms of applying and enforcing those, environmental, social, and governance safeguard standards, right? On the one hand, these institutions management say, you must allow us more flexibility, management, professional discretion. And on the other hand, from especially the accountability for harm perspective, is like, no, there must be some consistency in how you apply, the standard, at least a minimum core, whether you apply it in China or in a project in Tibet or in Bolivia or in Mexico or in Lesotho. And so that there's always that. And then finally, with respect to crisis management, Sanneke, yes, something I've mentioned about, risk management is very much an aspect of it. And this particular discourse on accountability in international organizations stemmed from crises, very controversial projects in the 80s and 90s that got a lot of media attention, even before social media. I cannot even imagine how it would have been done. And it was a huge embarrassment. Protests in Washington, D.C. at the annual meetings of the World Bank Group and the IMF, threats of international, EU-based NGOs and US-based NGOs, influencing US lawmakers to withhold funds specifically. And those crises really resulted in very specific actions to enforce or strengthen accountability, especially with respect to external stakeholders. So in short, I agree that there is very much still lots to be done and to be said, even though I have my moments where I also get tired. But on the other hand, listening to you and speaking to you and really fills me with new energy. I think it's a little bit draining to be in the US at the moment. I felt the last year when I went to South Africa to teach for most of the summer, it was as something lifted off my shoulders, even though I still followed the news and so on. But at the moment I came back, I think we're a little bit, you mentioned, Angela, that's on fire. I think we're sort of choking a little bit on the smoke, but it's important for us that we put on our oxygen masks and not lose perspective. So, and I think another aspect that we can do that is really to engage across disciplines, because after all, the only way we can build resilience in our institutions is through collaboration. And after all, even though we approach it from different ways and sometimes use different language and so on, I think increasingly, even though we formulate different research questions, but increasingly we are concerned with the same things. That's wicked problems, global common issues that we have, poverty, biodiversity, sustainability, climate change, and so on. And the only way we can do it is through collaborative, interdisciplinary research. And I was very happy to be part of this volume. Thank you, and I'm looking forward to engaging with you in future.
Thank you so much, Andrea, for a very thought-provoking and rich presentation, and also for describing the thought process behind the chapter. Without further ado, we proceed to the last presentation by Dr. Federica Violi, who's trying to access the computer, and I will put your slides on the screen as we speak. So. Federica, you're my last chance of bringing us back on schedule. So let's see how that goes.
That hopes in the worst hands ever. I think I'll sit for that one. Thank you very much to Yannis and Menelaos especially, but also the other editors for including me. It's been a wonderful journey for me, and the book looks incredible. I'm also really looking forward to diving into all the chapters. I've already learned a lot just from the presentations. I really, what Andrea said in the beginning really resonated with me. As in, how do I approach that? It felt really haunting in the beginning, and I've pestered Menelaos, who has, unfortunately, I mean, he's not so lucky, he sits next door. So I was constantly going to him, hey, but if I include that, what level of details do you expect? And if I include that other aspect, what audience would be able to read it? To the point that I think he started regretting asking me to join the volume. So what I did was an attempt at a mapping exercise on multinational corporations and the accountability, or lack of accountability of multinational corporations in the context of international economic law with, let's say, a critical flavor. So the idea was to try and also include some historical and conceptual perspectives while keeping the eye, let's say, on the prize and giving as much as I could of an overview of what's out there and what the limitations are. And I'll just start maybe with my main claim, which is that corporate accountability or the instruments that we have, be it soft law or hard law, are not sufficient to alter the structural reasons for the so-called accountability gap. And so I really like Douwe's point at the beginning. Lawyers love a clear premise or clear premises. And before delving into this sort of the variety of areas that I've looked into, I thought of myself, okay, what does accountability even mean in the context of international law and in the context of international economic law, as it is not what Andrea was saying also earlier, it is not a concept that is bred in law itself. International law, traditional international law, is rather related to international responsibility and subjectivity. And so just a small disclaimer, because of the meta considerations that also were shared by Andrea, I noticed that I had that in the reflex of including a lot of text on the slides, which I have no intention whatsoever of going through, just not to scare anyone. But so instead of finding a definition, I thought, okay, what are the questions that really guide my analysis? And I have relied a lot on the amazing work that has been done until now in the context of corporate accountability in international law, and I've clustered them into the subjective, objective, and procedural component. So these were really my sort of my line of inquiries across the different fields, and I've also relied partially on Mark Bovens' distinction of virtue and mechanism, because I thought indeed, and that is coming back a lot. I'm noticing the idea of virtue as a culture, and whether all these mechanisms that have been employed so far have indeed somewhat, triggered an enhancement in the culture of accountability in the context of multinational corporations. And my finding is that it hasn't happened. Second, very important premise for an international lawyer, but in general to understand also in terms of practical implications. What is a corporation? And why is that important? The question as to whether a corporation is or isn't a subject of international law has been out there since forever and hasn't been settled yet. But there is a reason why it is important to reflect on that, at least historically. Corporations have amassed, and we see that in our everyday, enormous amount of power. Yet at the same time, they constantly escape attempts at circumscribing it. And these can be traced back historically, and there is a wonderful work of Lustig that has been done in 2024 to the post-charter era. Corporations, very briefly, where the charter was a formal act of incorporation where entities that were not the states were able to make legal claims. And chartered companies in the Netherlands, this is very well known, were used for states' colonial endeavors. Already back then, this was actually much debated. And then at some point, the charter was dissolved, and with that came the idea that there would be a dissolution also of the relationship between the state and the corporation. So with the liberal turn, the corporation was sort of shoved into the private realm, contract, and out of the public scrutiny. So a state, home state of corporations would be responsible to regulate within their own boundaries, but that was not a matter of international law anymore, which means that now we have sort of a double escape. Attribution, and I won't go into that, I trust that you all remember that. In international law, attribution of wrongful conduct to states has a very high threshold. This means that the fact that a corporation is a national of a certain state doesn't necessarily trigger international responsibility of that state. At the same time, the corporation is not a subject of international law. So transnational harm, especially, which is, of course, the relevance of the chapter, for me at least, for my chapter, is out of officially obligations and binding obligations of international law. Because again, international law traditionally attaches obligations to subjects of international law, and corporations aren't officially such. Now, what's interesting to see is that while this lack of formal subjectivity of corporations is used as a shield when it comes to obligations and binding obligations, this isn't the case when it comes to rights and privileges, because especially in the area where I perhaps feel more comfortable with, investment law, we see how investors' rights and privileges are subject to an incredibly strong and highly enforceable system of rules and procedures. And we'll talk about that later on. What does this whole discussion about subjectivity, those obscure the actual root causes? So what's the problem with corporate conduct? It's authority. Corporates, and I had to think really about Mark's points earlier about the vertical and the horizontal and the private and the public divide. Corporations have, and that's again not a particularly original finding, have accrued quasi-lawmaking power. They have the ability of controlling territory. There are legal enclaves. Just recently, we are talking a lot about special economic zones where corporations act as sovereign, and they have the ability to enforce them. Menelaos really insisted that I would include, at least at a sort of an abstract level, an example that I always use. I look a lot at investment contracts, and I was looking in my past research on investment contracts between Cameroon and a US-based, and I'm being generic on purpose, and we'll see why. A US-based company was agricultural land, an investment contract to use agricultural land for the purposes of, I think, biofuel. And this contract between the state and the company would place the contract itself as an instrument, as a regulatory instrument of the investment operation between the Constitution of Cameroon and ordinary law. So anything coming from an ordinary legislative procedure through democratic, legitimate decision-making wouldn't affect the contract between the state and the investor itself. At the same time, the area that the company would exercise its control over was something about 50,000 hectares, which is pretty huge. And it also had the right to apprehend and detain anyone crossing the boundary of that 50,000 hectares. So we're talking of a quasi-sovereign type of behavior, which indeed reflects quite a lot the colonial structures that we are used to have. Now, what is interesting is that there is Kinari Bhatt refers to that as an hyperplurality of norms. We have a lot of different regulatory instruments that I want to say contribute to regulate corporate conduct, but also don't. In a way, corporates have managed to constitute the law, and I'm careful because Yannis Papadopoulos is online, in a way that would harden and entrench the hierarchy of power and their superior position in that hierarchy of power. So the accountability gap is not a case, and it's not going to be solved if we add law. It's structural. It's by design. All right. So what is left? And I promise I'm going to be very fast. The typical traditional international law approach is that whatever happens in terms of harms to the individuals under the jurisdiction of a certain state is the responsibility of that state. It's an indirect duty. We see it back also in the business and human rights system. So states have an obligation to prevent, investigate, and redress human rights harms on individuals on the part of other entities. Of course, there are a number of limitations. I just mentioned how powerful these companies are. So there is typically, we're talking about developing countries when it comes to the investment or any other type of economic activities of these massive corporations. Developing countries do not have the resources to put or implement that duty. And very often the problem is that if they do, then they always act ex post. So there is no control, no access to information on what they're actually doing before harm materializes. There is also risk of regulatory chill in the sense that developing countries tend to compete to attract multinational companies, which means that they're going to be very careful with what type of regulatory requirements they introduce. And the reality of the post-colonial states is very often one of complacency with multinational corporations. If we look at the judicial remedies and the access to justice of those who are victims of corporate harm within host states, the picture doesn't change much in the sense that, first of all, it's very expensive. I can't remember who mentioned that earlier. I think Mark again. So we also have, there is a form, let's say, what is available formally to the victims and what they actually can do, which is very little because, of course, we're talking about an asymmetry of power that affects also access to justice. And there is also the problem of the corporate legal structure, which we'll go back to in a second. It's probably a subsidiary of a major company, and due to the separate legal entity doctrine, the resources to actually redress corporate harm in the country would probably be very low. So what else is left there? Home states. Now, sovereignty in international law is conceived as territoriality. So any extraterritorial obligation that comes from the home state towards the corporate conduct of a company that is headquartered in the home state is just discretionary. The home state can decide to introduce extraterritorial obligations for corporate conduct, but it doesn't have to, which means that the entire responsibility for regulation is shifted again onto the host state, which we saw earlier is not very effective in protecting individuals. There is also another aspect, we don't have time to go into that, that is a little bit more delicate, and it goes to the idea of normative competence conflicts. Our notion of human rights here in this part of the world might be very different from the notion of human rights that we have in another part of the world. And that also creates tension, of course, when it comes to regulating conduct that is actually taking place abroad. The judicial remedies looks also quite grim. We've heard actually earlier a more hopeful description or rather analysis of what tort law has to offer, which is, I think, a lot. The problem is that it seems to be contained in certain countries only. The UK is quite advanced when it comes, for example, to parent company responsibility. The Netherlands has been, but many other countries, including countries that share our legal tradition, aren't. I just read a couple of weeks ago of this case, Barrick, in Canada, where miners tried to sue a mining company that was a Canadian mining company that was operating in Tanzania for having been subject to beating and severe abuse. And the Court of Appeal, I think it was, declared forum non-convenience. So essentially they said, sorry, we don't have jurisdiction, you should go back, you should go to Tanzanian courts. We also have the problem, as I said earlier, of the separate legal entity. So the concept of limited liability, are judges inclined to pierce the corporate veil? Not everywhere. And there is also private international law dimension to it, which is what is going to be the law applicable to the case and how is that going to be favorable or not so to the victims. So all in all, when it comes to home states and host states' responsibilities, the picture is, for me, at least mixed. We've seen some advancement indeed when it comes to home state judicial remedies through tort law and duty of care. Yet we we don't see any structural attempt at altering the power that corporations do have and exert. So that also means that have been a number of attempts at trying to pin down corporations with direct responsibilities. We don't have at the moment any set of, I want to say not even in the EU or not as extensively as we had hoped. There is no set of binding obligations for corporations right now at an international law level, but that is not, again, it's not a given. We treat corporate power, corporate absence of direct obligations and binding obligations as a given. There had been several attempts in the past. Unfortunately, they never materialized into a binding legal instrument. And that meant that with the appointment of John Ruggie as Special Rapporteur on Business and Human Rights, we had ultimately a set of soft law guidelines, the UN Guiding Principles on Business and Human Rights, focused on two principles, the do no harm, so the negative type of responsibility, and a human rights due diligence process. So substantive obligations were turned into, I don't want to say immediately a tick in the box, but okay, into a procedural type of, or at least a reporting type of obligation. There have been some attempts at hardening corporate accountability. We have a business and human rights treaty currently ongoing. Consultations are taking place right now, actually, and we expect a new draft at the end of 2026. But even this, it's hopefully going to be a treaty, but even this doesn't design and implement an internationally based system of accountability for companies. It requires states to domestically pass laws that would pin down corporate conduct to whatever system of civil liability they have. The EU had come very close, and when I submitted the chapter, it looked like it had made it, but no. There was a significant overhaul with the Omnibus 1, and there were a number of very relevant features removed from the directive, including the most important one, the fault-based civil liability, which was supposedly going to be harmonized across countries. It's now left to member states how they want to design the system of civil liability for companies, if at all. So that's for sort of the more traditional corporate accountability approach. However, there is another big elephant in the room, and I say elephant in the room because it has always surprised me how international investment law has been discussed so little in the business and human rights realm, at least until, I want to say, 2-3 years ago. What I said before, this is structural. Corporate conduct, the responsibility and supposedly obligations of companies were always left to the realm of soft law. Risk, responsibility, due diligence, do no harm. Soft law, at best, left to states to implement domestically some sort of regime. On the other hand, the rights and the privileges that are typical of the investment regime are incredibly hard and have a formidable level of enforceability. Now we see that this is sort of the bridge is coming up. We also see it in Principle 9 of the UNGPs, where states should try and avoid being excessively constrained by investment law regimes that do have an impact on their duty to protect the individuals under their jurisdictions. And so there has been a movement also in international investment law to reform the system and include some level of obligations. I won't go in through all of them. Perhaps the most important aspect is that, yet again, even if we hear a lot about investors' obligations and the inclusion of investors' obligations in international investment agreement, we have very little of that. Even when we read in the title of paragraphs within treaties, investors' obligations, if we look at the actual provisions, it's about corporate social responsibilities. How home states and host states should encourage corporate social responsibility, again, due diligence, do no harm, towards the investors operating in their countries. So there is a significant lack of directly enforceable, especially investors' obligations within international investment law. And I think I can skip that, and we can go back to that in the discussion if necessary. So what is left? It's clear that all this plethora of instruments haven't been as effective yet. There is a diffuse regulatory movement when it comes to accountability. There is no center of accountability. That also means that we have different level of enforceability, different level of stringency, and very often these regimes are also either not talking to each other or even conflicting with each other. And that leaves the space very open for, again, corporations to exercise their influence. At the same time, what we see hardening are reporting type of obligations, transparency types of obligations. But self-reporting and transparency obligations haven't been able to create that virtuous culture of accountability that one would hope. And the problem is that and really that's my final point, we have been asking the wrong question from the very outset. We take corporate power as a given. We don't question it. All of these regimes that I've mentioned take corporate power as a given. Instead of asking, how is that corporate companies, corporate entities are even allowed or get to exercise that level of power? And that goes very much to the root of our current legal and economic system and the way it is structured around extraction and exploitation. So it requires a much radical rethinking, not only of corporate accountability or corporate subjectivity, but the way that we actually organize our system of global governance. Thank you.
Thanks, Dr. for a great presentation. That was also a masterclass to all our students, even after their exam week. But the grind never stops, and the learning never stops either. I will kindly invite you to stay here, and I will also invite Professor Amtenbrink and Josh Norman to join us on the panel, and I will make sure that Andrea is back on the screen so that we can proceed with our discussion. Yes, so we have everyone on the screen. I will make both, so please do sit down. Professor Amtenbrink, whenever you're ready, the floor is yours. You need a table. You can use this one. I will sit on the side. You can use there.
Yeah.
I'm sitting here.
We will address it with our vice dean for research.
See what we can do for real estate and facilities.
Yeah, thank you very much. Thank you so much, Menelaos, for letting me comment on this. Especially since both highly respected colleagues of mine, or former colleagues, present colleagues, have done their utmost to go outside the book, so to say, and kind of like, doing this tour de force on what they think needs to be said on the topic. Whereas I was being a compliant citizen, reading these chapters and thinking, okay, so here are my some more detailed context comments on the chapters, which of course, in a way, given that we have gone all the way to radical rethinking here, it seems a little bit, I'm kind of like on the millimeter, while both Andrea and Federica have been talking about basically global revolution. To some extent, depending on where you take your comments. And if you take them serious, that has major implications, and especially Federica knows how much of a fan I am of these radical rethinking. So where do I start? Essentially, both publications focus in their own way, and I mean this in a positive sense, in their own style, in their own approaches,
on accountability, interestingly enough, on public power on the one side, right? Public power, public influence, Andrea. So it's not only like formal power, and on private or corporate power / influence, right? Both discuss the notion of accountability to some extent, perhaps not as orderly as I would have liked it, but on the other hand, of course, there are other contributions in the book. So if everybody would have done the same thing, then you would have had a lot of repetition of everybody going through the notions and everybody probably citing Mark Bovens, and so which may or may not be the gold standard on accountability. That's a separate discussion, but it's quite interesting. It's also quite interesting when you approach it from the other side, and I will say more about this, kind of like and what is not discussed. So and there I also found quite interesting for myself two things. And you tell me if I'm wrong. What is not so much, I'm covering myself, not so much discussed is, if you want, the link between accountability and legitimacy. And what is then the role of accountability in legitimacy? And I mean, that's an even bigger can of worms than accountability, legitimacy. And especially if you add the D word, democracy, to it, which by the way already is can provide some fun and games when you do that for accountability. So what's the difference between accountability and democratic accountability? And is there a difference? And does that possibly, that would be my suspicion, complicate things even further? Especially in the international sphere, right? So I was wondering whether possibly you would like to comment on it, perhaps. So starting with Andrea, yeah, I totally agree with the first part, what you started off with, that it's extremely challenging to comment on your paper. Whether it's extremely rewarding, what I have to say, to quote you in a way, probably not, because it's a well thought through piece that shows that the author has a lot of experience in working in this area, and I am not. Right, so this is not my particular expertise. I have written on the accountability side of things, and there maybe I could yeah, a couple of comments. So the first one I really liked, when what you focused on also doing your presentation on this need for interdisciplinarity, right, and interdisciplinary research on accountability. Now, one of the things there I found always interesting in the past is the differences in approaches to the notion of accountability you see there. And in my parts of the woods that I've been working on, which is basically monetary policy and all things related to that, you see a stark difference between how a lawyer will regularly identify or define accountability and how economists will do it. And this actually results to some major differences when it comes to these two groups evaluating certain institutional arrangements as to whether or not there is sufficient degree of accountability. Give you an example. So economists, for example, will very much focus on transparency, and they will focus on performance. Whereas lawyers naturally will be more looking into the evaluation, the assessment of performance, and then retaliation. right? In the sense of, okay, if I don't like the performance, what kind of consequences can I attach to it? Now, these are actually, that's not quite the same, these two, in the sense that you can have wonderful transparency arrangements in terms of publications, disclosure, yeah, and wonderful performance in the sense that all the objectives are met, but we lawyers would possibly still be very unhappy with the accountability arrangements. Yeah. Whereas an economist would say, what's the problem? If you translate that to Vivian Smith's triology, if you want, of input, throughput, output legitimacy, you could say in a way that economists are more concerned about output legitimacy, and they see that kind of like as a way of almost accountability. I find it really strange, so I can almost not say it, but that's kind of like the way in which the conversations that I used to have and still have with political economists. So I was really wondering in a way, Andrea, that what is then your definition of it, or where do you see yourself in this, and possibly there are even other ways in which you can improve this. You have this discussion on accountability for performance or for harm, and then I was, and that's just my lack of imagination, really wondering what exactly. How does that make any difference in a principal-agent relationship where accountability comes in? Or is it that accountability for you is about performance and responsibility is about do no harm? Now maybe I'm completely misreading what you're writing, and for those that haven't read the chapter, you will really wonder what I'm talking about now. I'm sorry, but it's something that you're discussing, and I wasn't quite sure how to put it. Very much like what you said about basically in my translation, who is the principal and who is the agent in this principal-agent relationship, which of course at the international level and with international organizations may be a very complex one and so diffuse that you end up basically without any accountability, because everybody and nobody really feels the responsibility for that. Standards can facilitate accountability for performance and harm, quote unquote, Andrea. At the same time, you talk about yardsticks. So are standards, in your view, a clear yardstick, or the same even, or is it not that standards most of the time are anything but a clear yardstick that you could use to evaluate performance? And I'm going to give you a very quick example that Menelaos will know very well, and that is the difference between a yardstick as you find it for central banks. For example, price stability, and then price stability is defined. Some who visit my course will know what I'm talking about. But if you look at banking supervisors, right, what is the yardstick, right? And so what you look in the legislation for banking supervision, and what you will find there is something like financial stability. So you could say that's kind of like a standard, but what does it mean? So at what time does the principal in a justified way can argue, I'm sorry, you're not performing well? That's very difficult to do. So I was wondering standards and yardsticks, and then finally. International organizations should be accountable for the exercise of public authority, quote unquote, whereby you discuss both exercise of public authority or quasi-public authority and the issue of the legal personality of these international organizations. And I was wondering, does it really matter whether they exercise public authority or quasi-public authority, and how do you define that? Or is it really about the impact, the influence they have on decision-making processes, and maybe that's kind of like the same, and we just have a different way of saying this. Yeah, so that today's and then finally, may or may not be the killer a question: is accountability of international organizations still relevant? And I'm sorry, it's a bit of an open door, and somebody has to kick it in if nobody else has done it today. Unfortunately, I couldn't be here all day, and that is, of course. It comes down to, do international organizations still matter? And to what extent do they matter? And if they don't really matter, why should we worry about